Welcome to Difficult Research. Welcome, everybody. Come on in. They're going to have jury instructions today. This is Difficult Research channel. It's a channel. Sorry. Let me turn down the sound in my background. I should know better, huh? So, today is the day they're going to do jury instructions. And I'm guessing we will not be late today starting. Because, I could be wrong. Does anybody know that? I would think that the broadcast would start on time. Oh my gosh. KJ says that, okay, folks, so KJ is having Red Bull and BC powder in honor of all the mods who helped us through this. Cheers, mods. I know that's a crazy thing. We really have had, I'm just going to say, everybody's been pretty well behaved. It's been, Lori has been the worst behaved person in all of the chat. Excuse me. Let me unmute that. I was coughing. Let me get down this background. I have to figure out if y'all knew it's just like this is like a damn air traffic controller thing. Sorry for the cursing. Let's see. These are backgrounds, right? Overlays. These are overlays. There it is. There I am. Okay. So it looks like I've got up the law and crime, but also available is the, let's see, is the before prison is going to remove the other one. Okay. So I've got this one available too. And it should be starting just any time. Y'all, I've got two computers going today. So let's see if it's actually, they're waiting for it to start. So when it starts, we'll go on and get that up here. KJ, would you want to come up here and share? If you're not too deep in the Red Bull. See, I'm not looking at the comments. I wouldn't know. Hey, Bewitched. Hey, Jeff H. Jean Marie, Beach Bomb, and Frank. KJ's here. Hey, Marilyn. Melanie Lewis, Lisa Haynes, Little Brands. Trace on the case is not in court today. So she's in the chat with us, so y'all can still ask her questions. I'm sure y'all got some. Maybe we'll get her up if she wants to come up and give some commentary or do something with us. Kim Top, Jeff H, DT, Angela Davison checking in from Facebook. See, we can't see your messages in YouTube, but we can see them in StreamYard, and we can show them. Yes. Beach Bums. Let's see. Lisa Hayes says one of Lori's final days before all she sees is prison walls. That's right. No more makeup, hair doing from. I thought that she keeps saying that Arizona is the worst prison in the world, but at the same time, they gave her makeup and hair doings and let her talk to interviewers. So if she when she goes back to Idaho, she won't get no interviews. She won't get no there won't be any makeup in the commissary. I don't know if they call it the commissary. Is that what they call it? Is Nate there? Let me see if Nate's there. I bet Nate is there. If Nate's there, he's not saying anything yet, or I'm not seeing him say anything yet. There's always that possibility. You know, I'm not an expert in Twitter. So Justin says that court will start at 10:45. So actually, that's 12:45 here. So it's a while yet, and I'm thinking that that it won't be delayed. Am I wrong to think that? Maybe it will be delayed because she's the one going to be talking. But I was thinking it was about the jury and not accidentally take. Does anybody know? Trace says that Nate told her that the warden in Idaho is like a social worker and there's all kinds of social activity that Lori loves to do there. Oh, I see. Well, I hope one of them is scrubbing floors or something with a toothbrush or something. Sorry, that's very mean, Donna. You're very mean. Hey, Miss Vicky. So glad you're here. Janet Laughlin. Glad you're here. Maga Mom. Glad you're here, Maga Mama. Just me. Charlotte Bassett. There's no cameras. So if there's no camera, is there no feed today? Trace, no feed today? Huh. I was thinking that it would be like a regular day that the jury wasn't there, like in Idaho, but you may be right. It may be that we don't get to see these hearings. Does anybody know? KJ, would they have to would they be allowed to hold these jury questionnaire things in private without having? Yes, I know they're going over court. They're going over questions for the jury, so they're jury instructions and all that. You don't think there is anything? Well, it should be public, KJ. I agree, but I was wondering. Well, the others have a stream set too, so there's stream set. So whatever they're going to do, we're going to see it. I know that Law and Crime and Fox 10 from Arizona, where Justin Lum are both sending it. Me too. Well, I don't know, Trace. It was kind of confusing when they were given the directions yesterday. I got them twice because I was trying to get them out of the tweet, and then I heard them again, and it just got me confused. But okay, so we got. Are they doing anything yet? They got chat going, but they don't got no. Yeah, we want to see what Lori objects to on the jury questions, because she will no doubt object. Caroline I says, then Lori was going to tell the jury that she rests unless she changed her mind, and then they're going to get together on Monday for closing statements. So I understood that she has to tell them before Monday if she's going to testify, because if it's going to affect the jury questions and the schedule. So she needs to tell Judge Berinsky. Oh man, is that how you say his name? I've even forgot right now. Tell the Judge B that she's going to testify or not today. That's what I understood. Because if he's got to know before Monday, it's okay, Fancy Nancy. I have done deleted things and other things, and most of the time I don't even know how I did it. Jay says she's such a control freak. She'll wait till the last minute to say what she's going to do to hold everyone in suspense. That's what I'm saying. I would think that it would be important for her to tell him today. That's okay. That's what KJ says. If she changes her mind, she will have to tell him today. So that's what I think too, because otherwise they need to know about so they can affect these jury instructions today that they're planning, and also the schedule, because they'll need to allow time for both her to say her testify or not testify. I guess it would be for her to be testify, and then for them to cross-examine her. That could take a while if she were to do that. No, Red Joel, she has not said yet if she's going to testify. She was putting that up there. Okay. Can we do a poll? I wonder if I can. Look. Pop out chat. I don't see that I can do that with my tools here. Yeah. Brutus is unhappy about something he heard outside. People are working on houses all around me, and if they're dropping something outside, or I hear yard workers and this and that, and Brutus just wants to bark about it. Trace, I haven't seen if Nate's there or not, but I feel like he will be. But what do I know? If not, we're just going to visit for a while and read the tweets as they come out. Okay. We're getting a tweet from Justin Long. Justin says, still a very important day, and the question remains if Lori Vallow Daybell will change her mind about testifying. So, y'all, we're having the same question. Justin is saying the same thing we are. And so, okay. Put a 1 in the chat if you think, oh gosh, I may be, okay. Put a 1 in the chat if you think that Lori will tell him she's going to testify. Put a 1 in the chat if that's what you think's going to happen here. Let's see if Nate's saying anything yet. Okay, let's see, Nate. So I don't think Nate said anything yet. That doesn't mean he's not there just because he's not tweeting yet. Let me look at my chat over here. Uh-oh. No, 1. Okay, so most everybody thinks that she will not be testifying. Yeah, she can't follow rules Trey says she's not going to. She would have to follow rules of testimony, and she don't like to follow any rules. That is true. KJ says, I have to agree with Trace. Okay, Michelle says that Nate did a live before heading in. Well, let me see if I can find that. So y'all watch this right here while I look. to see what do Nate say. Oh yeah, I guess I have to put. Man, I just put Nate in the YouTube, and it doesn't know what to think about that. I don't know what's the matter with me. Silly me. Okay. Okay. So we'll watch a little Nate.
Eight, I guess you could say, of the trial. We're going to call it day 8, even though the jury won't be there today. Instead, what's going to happen here in just a few minutes, about an hour from now, Lori Vallow and her defense team and the prosecution's team are going to get together with the judge and all agree on jury instructions, the instructions that will be read to the jurors on Monday after there's closing arguments. Okay, can everybody hear me? Let me know if you can hear me. Hi, I think you can hear me. Otherwise, you'd be saying, I can't hear you. Good to see where you're all watching from. Okay, yes, they got me. Good, you got me. Quick recap of what happened yesterday. The one witness for the prosecution, Detective Nathan Duncan, was on the stand all day long. And then Lori Vallow cross-examined him. And then the state said, we rest. And then Lori Vallow said that she felt the state did not prove their case and asked the judge to toss it. The state responded and said, no, we did prove our case. They both had these prepared statements, you could say, that they read. It's more of a procedural type thing. The judge said, no, there is enough evidence that was presented that a jury could find you guilty. Not going to grant your request. And then Lori said, okay, then I rest. Well, she rested outside the presence of the jury. So she could still change her mind. And the judge said she could, if she decides to testify on Monday, she could. But she needs to let him know if that's going to happen. The interesting thing is that she has no other witnesses. She has no other testimony. So it would just be her. I will be shocked if she changes her mind. Lori loves to be in control. If you couldn't tell, she likes to be in charge. And if she goes on the witness stand, sure, she can be in charge of what her defense counsel asks her, but she has no control over what the prosecution asks. And many of you asked, what happens if she takes the stand and pleads the fifth or says, I'm not going to answer that? Well, for a normal witness, you'd be in contempt of court and could go to jail. I don't know what they do with her, though. I guess you could say that it just won't look good in front of the jury. The jury's going to be like, why isn't she answering the questions? She has nothing to hide. If she's truly not guilty, why isn't she answering the questions? So we'll see if she takes the stand. If she doesn't, then the jury takes the case. And they have to decide if she is guilty or not guilty of the of conspiracy to commit murder. And whether they take an hour or whether they take a day or whether they take a week to decide that is to be determined. So for today here, Lori was being brought over from the jail a little early, I think around 10-ish. She's probably on her way right now. And she's going to meet with her defense team privately to go over these jury instructions. And then the prosecution is going over them. And then they'll get together with the judge. And how it worked in Idaho is the judge said there was a lot of instructions. I don't know, 30, 40, like you go line by line. And those are the instructions they need to follow when they go inside to deliberate. And so how Judge Boyce did it in Idaho was he said, all right, it appears no one has any issues on instruction number 1 through 20. What about 21, 22, 23, 24? It went fairly quick. I imagine today will be fairly quick unless one side has an issue with how one thing is worded or not. And then we break for the weekend. For Easter weekend, I'm going to sit down here before I head inside. We break for Easter weekend, and then first thing Monday morning, it's closing arguments, and then the instructions, and then we go off. It's off to the deliberations. Okay, I know a bunch of you have a bunch of questions. Why isn't she eligible for the death penalty? Because it's not a first-degree murder charge in Arizona. If it was first-degree murder and there was aggravating factors, meaning it was especially heinous, or a police officer was shot, or the law defines what an aggravating factor is, and then the bar is higher on those type of cases. So that is why. Why wasn't any of the video from Tylee or Charles brought in? Because, oh, thank you, Jennifer and Julie. How nice of you. What a cute little, what is that, a fox? That's awesome. Thank you for helping us, supporting us. It's hearsay. And you know what? Tonight on Courtroom Insider with Rachel Smith is our special guest, and Alan Browning, a defense attorney. They're going to join me tonight. We're going to talk about all of your questions that you guys have had. But basically, even though Charles is no longer here to authenticate the video, it is hearsay. It's his words, and it's Tylee's words. That's why they haven't brought in those videos. And that's why they didn't bring in they could have, I guess they could have played the call that Chad made to the funeral home. But again, he would probably have to authenticate that. Do they really want to have Chad Daybell come in and authenticate it? So we're going to talk about all that stuff. Someone's asking if I'm surprised it went this fast. I don't think so. I actually thought it might be done in a week or two. And actually, I guess if you look at the number of days it has, because we're on day 8, and some of those days have been short. The prosecutor originally said 1 to 2 weeks, and then when Lori Vallow decided to represent herself, they said, "Oh, we're going to need a little bit more time." Fiber, floozy crafts, that's fun. Thank you. So, and Lonnie, wow, you all, thank you. You're making me get lunch, so I appreciate that. So yeah, that's how it will work. Did any of Lori's cross-examination land? I don't know. That's a good question. You'd have to, I guess we'll see. All it takes is one juror to have a question to raise some doubt, to be like, no, maybe Charles really was bullying. I don't know. Nate, am I going home for the weekend? I am. I am going home, not you. Maybe you're going home. I am going home to Idaho and going to be there through Easter, through Sunday. But we will do Courtroom Insider tonight. I'm excited about tonight. And then on maybe tomorrow I'll do one with my wife from home, and we'll see, and maybe answer your questions. I don't know. We might just want to unplug, but I know you guys really like when Erica comes on and we could be together. And then Sunday night I'll do a here's what we can expect type of a thing. So yeah, we'll continue on with Courtroom Insider, but going home to Idaho, looking forward to going home for Easter weekend, seeing the kids. Could Lori write a book? She could write a book, but she cannot make money off of it. There's slayer laws, which in Idaho you cannot, I think here too, you cannot make money off of your crimes. Nate, you really have to do an interview with Zach Cox. I'd love to talk to Zach. I think it would be great. I'll reach out and see if he'll talk. I've spoken with Zach in the past, not on the record, but he's done a few interviews, and then it would be great. Is your wife afraid Lori might cast a spell on me? You know, in the early days of this case, we were a little scared. There were some weird things happening in our office. Right after I went to Hawaii, we hired security for our office, and the police department went by my house and we put up cameras. I don't know if they were tied to Lori or not, but we were a little nervous. I'm flying into Idaho Falls today. Hey, Kira, that's great. Good. When she's found guilty, will she go back to Idaho to serve her time? Yes. Regardless of the verdict here, guilty, not guilty, she'll head back. Now, I don't know if she waits here till after the appeals. I doubt it. I think she'll go back to Idaho, and then while they work on the appeals here, assuming she appeals, she might just say, forget it, I'm not going to appeal anything, but she's likely going to appeal. Man, you guys are all so generous. Thank you very much. I appreciate that. Yes, someone's asking, does all the money go to me? I guess technically no, but it goes to help me stay in Arizona and cover these trials, so I can say, you know, look, the trip was worth going. Someone's asking about the other trial. I'll be back for that. That one, jury selection is supposed to start on the 30th of May. And then the trial will be all throughout June. It's like the first 2 weeks, and then we have a week break, and then it's scattered throughout. Please interview Howard Bloom. I have Fiberfloozy. I interviewed him about the Idaho 4, the Kohberger trial. If you can find it on our YouTube channel, and I'll have to have him back on. So he wrote a book about the Kohberger trial, and yes, I'm planning to cover that. It's snowing in Pocatello. Oh, wonderful! After the hearing today, I'm gonna go back to the hotel and put on my shorts and flip-flops. Not looking forward to that. Is trial about to start? No. Well, kind of. The hearing will start in about, well, I think around 10:30 Arizona time, which is about an hour from now. So I'll have to let you know with that, with what's going on there. Oh, thank you. I appreciate that I'm looking handsome. What is the other trial? The other trial is Brandon Boudreaux, the attempted shooting on him. Are you interviewing Nancy Jo? Please do it. I have requested an interview with Nancy Jo. I would love to talk to her. So hopefully that works out. I've also requested interviews with the prosecution team, the defense team. I plan to stay in after the verdict next week, assuming we get a verdict. I'm going to stick around Arizona for a few days just to try to get some interviews with different people. Today's hearing will be streamed. Yes, we will stream it. I don't know how exciting it's going to be honest with you. It's going to be a lot of back and forth, but you never know. You never know. It could be exciting. I hope the jury caught Chad's wife, Tammy. Yes. Has she officially rested? She is not officially rested. She said she's going to rest, but she has not rested in front of the jury. Will I interview Summer again? I would love to interview Summer again. And someone asked if she's going to be at CrimeCon. I'm not sure. I think that they are working on their CrimeCon lineup for September. So if you're in Denver, would love to meet you. When are you and my family coming to London? That would be amazing. We are actually talking about doing an overseas trip next year or the year after, when our youngest can maybe appreciate it a bit more, like saving up our money and maybe going to Australia and New Zealand. So that would be great. I need a verdict before Karen Reed's trial start. When does Karen's trial start? Did they pick a jury on that one? Honestly, I've been so tuned into this one, I haven't been following Karen Reed much. So let me know if they picked a jury. Is Lori going to be her lawyer at the next trial? Yes, she is. As far as we know, she could change her mind, but I think for now she is. Same prosecutors for Brandon case? Yes, and I'd love to interview Brandon as well. I've spoken with Brandon. I don't think he'll do any interviews until after his trial, if he does any. He's kind of laid low, and can't blame him for that. Okay, Karen Reed starts Tuesday. Well, then wouldn't that be perfect? If we get a verdict Monday, then you all can go right into Karen Reed. I won't be going to Karen Reed's. I'm going to go home and prepare for the next trial. But yeah, that would be interesting. If I guess I could go work for like Court TV and jump around. Do you really? Lori's ready to leave. Said she's ready to leave jail and get into the prison. Do you really think she'll like it better? From what I have heard, Lori doesn't mind the Pocatello prison in Idaho. She liked the wardens. She liked the view. It's actually, that sounds crazy, the view. It's on the top of a mountain, and it's actually a very beautiful view. And she liked the people. She does not like it in Maricopa County. So, yeah, I really do think that she is ready to go. The accommodations here aren't the best from what she says. Pocatello doesn't want her. Well, okay. Does she have until Monday to decide about testifying? She does. Maybe the judge will ask her today and she can officially say no. I would be shocked, pleasantly shocked, if she does decide to testify. Another Summer Shiflett interview is due. I'll reach out to Summer and see if she'll talk. I think we do have questions now with all of the stuff that came in yesterday, how much Summer knew and what her involvement. So yeah, I'll see if she'll talk. Does the judge pick the penalty or the jury? The judge does. The judge will sentence her. I don't know if he'll sentence her and how quickly he will sentence her, but we'll see exactly how that works. But he will sentence her. He might wait until after Brandon's trial and do it all at once, or he might sentence her in 30 days. We'll see. Hoping to meet me at CrimeCon. I hope to meet you too. It's going to be a really fun CrimeCon this year, and we're working on. I was talking with them just the other morning about some.
After saying that the state did not present sufficient evidence to show that she conspired in the murder of her fourth husband. But it's like 99.9% rested for her.
Right, right. One last cliffhanger in all of this. She is that much closer to resting her case and not taking the stand, but left the window slightly open that she could still do so. And maybe we'll learn that this morning.
Yeah, there's always a cliffhanger. There's always this question keeping us on our toes of what's going to happen. Judge Boreski, who has been quite calm and collected through all of this, 7 days of trial does not feel like 7 days of trial. We have seen a lot. We have heard from 19 different witnesses. Lori Vallow Daybell does not have one to call. So I think the prosecution clearly felt very confident, didn't have to get through all 21 witnesses, finished with lead detective Nate Duncan, and we finally got to see into the window of the affair between Chad Daybell and Lori Vallow Daybell, and what they were saying about Charles Vallow, the life insurance change, spiritual, financial, you name it, and had it all, and not to ignore the shooting that happened involving Alex Cox, who died in December 2019. So a lot of you have questions. Thank you to everyone watching. We have about 300 people watching. Hello to you all. Today's not going to be the most exciting day, but I think it's great that we have a camera in the courtroom and we're able to see jury instructions and how both parties review those, the questions they have, because these are the instructions that the jury will be getting after closing arguments on Monday.
Yeah, and they're going to be pretty easy to follow. You know, we talked about the previous two cases in this saga, how many counts that the jury had to go through, the decision they had to make. So we are at a point now where it should be pretty easy for the jury, once they start deliberating, to make their decision. They have one count: conspiracy to commit murder. I don't know. I know, like you said, this trial has felt like longer than 2 weeks.
Yeah.
But yesterday, so much was introduced. Prosecutor Trina Kay really was her star witness, and we were not shocked. I guess that we knew she had two more witnesses to call, but I feel like most of us felt like this was really her best witness
Hmm.
and probably the best way to end it.
Yeah,
Um,
yeah, I thought that's what we thought, but us looking at the number 21, we just kept assuming, oh, there's two more. But why did you not end with Duncan? But she did. Um, Now obviously Trina K very experienced and something as yeah, like I said, this is not going to be exciting today, but we will see the cracks and see the lack of experience on behalf of Lori Vallow Daybell because she's not a real attorney. She's acting as her own attorney. But I was talking to Rachel Smith this morning, special prosecutor on the Idaho case, and she told me, I'm reading the message right now, one of the places most vulnerable on appeal is instructional error. Courts expect trial judges to get it right. So the appellate courts view instructions critically. This is an area that Lori will be most ill equipped to be her own attorney. And really, it's one charge. It's not like in Idaho where it was first degree murder in the death of JJ Vallow and Tylee Ryan, conspiracy to commit murder in the deaths of the kids and Tammy Daybell, and then also grand theft by deception for both of her children. Like there were a lot of instructions that were very critical and had to be reviewed for the jury to even get those instructions. Um, so this is one charge, conspiracy to commit first degree murder. So it shouldn't take long, but you know, this is where she lacks the experience.
right. We will, I think, get a pretty good idea if she has anything to say today, regarding her case moving forward. I thought, as you mentioned, Boresky's done a great job throughout this trial, and I thought he made it pretty clear to her yesterday where she stands and what she needs to do to close this chapter, so they can bring the jury in on Monday. Closing arguments. We heard Trina talk about how long it would take her.
Mm-hmm.
Obviously, Vallow or the Daybell, Lori Daybell, indicating her closing arguments wouldn't be nearly as long as Trina K's, and that may be good or bad for her or the jury. And then we'll figure out how long they need to deliberate. But like you said, today's developments, they're getting back into the court now. Should be pretty short and sweet. But maybe we'll finally get an answer about Lori's decision to take the stand. Hopefully,
Well,
we
she
will.
can't officially rest until the jury's in front of her, and they're not reporting
Yep,
today. So
right.
she actually has more time than we think. She's been thinking about this since last night, or maybe she's made up her mind, and we are not getting that change of mind. Court supposed to start about 10:45. We know that Lori Vallow Daybell and her counsel have already met minutes before this, but at 10:45 they'll start going over these jury instructions. And according to Rachel Smith, prosecutors, they spend a good part of their closings explaining the instructions and the law. How key is that in presenting to this jury of 14 right now what they need to do in order to follow the instructions? And she will ask them to find Lori guilty of conspiracy to commit murder. She says that Trina will probably use a PowerPoint to walk them through that. And prosecuting attorneys always anticipate a jury to have legal questions. So they want to address those things and put them in closing arguments. And that's why she expects to go more than an hour.
Yeah, if I remember correctly, in Rachel's case, the jury had some questions, I think, regarding some of the things they had to decide, because there were, like you mentioned, a number of things that they had to weigh in on
Several
in their
charges.
decision. This, again, pretty cut and dry. You've got 12 jurors, 2 alternates. And we go back, the jury has asked a few questions. Most of them have been pretty simple and to the point.
Mhm.
So I would be shocked if they had any other questions at this point. I thought yesterday would have been the day that they would have had more questions than other days.
Yeah, I think as far as evidence, they're done. If they have any questions, it's going to be about these instructions. But really, for one charge, that's why I don't expect this to be a very long day. But who knows? Again, you have someone who is representing themselves and doesn't have that experience. But I think for Trina, this is just dime a dozen. She's done this many, many times. Um, but I would also like to note that Court TV, we know, is the pool camera for this. They have put in a request to distribute the broadcast of the verdict when the verdict is read live. So it'll
Yeah.
be no 30-minute delay if they get their way. If Judge Boresky says, yeah, that's fine. Just like in Idaho, it was live. I think that was huge in the first trial because there's no cameras. And then when we got to the verdict, they had a pool photographer from the Associated Press for stills, and then they had their Zoom camera set up for the live verdict to be read because at this point the verdict is in. So I don't see that there will be an issue, and you guys will be able to watch that with us live, the verdict being read to see if Lori Vallow Daybell is guilty or not guilty for the death of Charles Vallow. So that's something that we're waiting on and we're tracking. But first things first, these jury instructions, and then, if Lori sticks to this path and does not testify, her best bet, like I was saying to Ron Hoon in Fox 10 Talks earlier, is to present her case in closing arguments. But she didn't really answer questions for the jury, did she? When, not that it's her burden to, but in opening statements, she says the evidence will show that self-defense is not a crime.
Yeah, I feel like if you read into it, I guess from her perspective, she kind of alluded to it in the Rule 20 yesterday, that that the state didn't provide enough evidence
Mm-hmm.
to prove conspiracy. Um, you know, we talk a lot about in our business, you kind of lay out the dots and let the people at home connect them. I think in court, you could make the same argument. You could certainly use the same justification. Is the prosecution lays out the dots and hopes that the jury connects them like a normal and reasonable person would.
Yeah.
Yeah, no, there's no video, there's no audio where Lori tells Alex, "Look, I need you to kill Charles because I want his money." Right?
Yeah,
In a
it's not
perfect world,
literal.
that's the smoking gun. You don't have that in this, so maybe the jury picks up on that, but they need to connect some of the dots. At least that's what the prosecution is hoping, that they see all of this. They read the text messages. They see the demeanor. We've talked a lot about a lot about Lori's demeanor on the morning of July 11th, and her whereabouts and her leaving after the shooting and how long it took Alex or anyone really to call 911. You hope that those are the dots that they connect, and that the jury sees, okay, you know, do we have the smoking gun for Lori? No. But do we have enough to suggest that she knew more than she's letting on even now? Maybe. I think
Yeah.
that's kind of what the prosecution.
And obviously, it's easy for us to make more judgments or connect the dots, and we've been suspicious of Lori the whole way in the context of what happened in Idaho. But if you're the juror that hasn't seen any of this until the last week or so, I don't know if it's as easy. I mean, maybe there's one juror that says, "Oh, I don't think there's enough." Yeah, they may think that she acted shady and
Right.
didn't care about her husband, but they may not think that these weird text messages are enough. We are unbiased and we are fair in our coverage, but we're also talking about a convicted murderer that did not cooperate with authorities at all in telling them where her children were. She lied to many people about how Charles died. So there were just so many red flags in these cases. As journalists, I mean, sometimes the truth, what is the hope? The truth is finding the truth. And you want to be fair, and she's innocent until proven guilty. But like you said, if you connect the dots, this looks like a conspiracy.
And we obviously know more about, we have more dots to go off of than the jury does, because we know about the other cases. We know about the mounds of evidence related to the children, to Tammy. Like, we obviously can connect more dots and know, okay, there was something more nefarious going on here. Maybe you're right. Maybe there is a juror who's like, look, I need the smoking gun. These dots, all of this factual evidence that you've given us in court, all of that's great, but there wasn't one piece of evidence that pointed to Lori holding the gun with Alex, or, again, we don't know what went inside the home, whether there was a quote unquote fight or not.
Yeah.
If you can find somebody who knows absolutely nothing about Lori Vallow Daybell, maybe you could make that argument. Like, look, guys, this is all great, but nothing here shows me that she pulled the trigger.
And I was talking to friends this weekend, personal, but there are people that really don't know a lot. They know her name, and they have the facts wrong, and they don't really know the entire story, and that's okay. They haven't followed it. They haven't really digested and even tried to digest all of this. So, but will it be harder to find a jury for the next trial? Probably, because every video of Lori Vallow Daybell that's posted online by us or any other media outlet, this trial, whatever is including her and her name, it gets thousands and thousands of views and gets circulated.
And I would think the next case is going to be much harder, because there's less circumstantial evidence to tie her to that. We saw some of those texts yesterday, but
okay.
Yeah.
So we're about to get started as far as real time, and we'll be tracking what's happening in the courtroom for jury instructions. But we aren't leaving, you guys. We'll see you in 30 minutes as that starts streaming. We're going to let you see our last episode of On the Record from last night. See you in a little bit. 7 days of trial, 19 witnesses, and the state of Arizona just rested its case against Lori Vallow Daybell, the so-called Doomsday mom, also resting her case without presenting any evidence. But there's a twist. She didn't rest in front of the jury. Is there a chance Vallow Daybell changes her mind and testifies to finish her defense against the charge of murder conspiracy in the death of her fourth?
So I thought I better, because it's doing that music, we're not supposed to, it's copyrighted, we don't be stealing their music. Do Trace, do you, or KJ, or Beach Bum, or one of y'all Mary, the detective's daughter, she's at the dang hospital. What am I saying? Okay, I'm telling people's business. I apologize. I guess we can see what he's saying. No, that was last night. We don't want to do that. So let's see if Nate or somebody has it. I'll share. Okay, Nate's back in the courtroom. So what I'm going to do is I'm going to remove that. And no, I meant to stop screen. So, okay. Okay, so well, I shouldn't. Hang on, y'all. Hold, please. Let's see. Present. Share screen. So I'm gonna share y'all some Nate. So Nate says 2 minutes ago, we're in the courtroom and there are, oh, am I on? Yeah, I'm unthinged. So Nate says, we're in the courtroom and there are a handful of people from the public in the gallery, but lots of empty seats. Trina Kay and her paralegal are at the prosecutor's table, and the prosecution defense will go over the jury's instructions with Justin Berensky, and the court will be in recess till Monday morning after that. Nate says that Judge Berensky just walked in. One of Lori's advisory attorneys says they need a few more minutes, and the judge has already some changes they need to make to the questionnaire. So I guess I could put some of that in here in the chat for y'all. I'm not catching up here. Remember, these are just Nate and Justin's comments, so they're typing. They're subject to make little mistakes and stuff too. So they're saying they've got to have some more time to look at some questionnaire thingy-dooey. So this is from Nate. I should have wrote that. But you can see it's from Nate. So I'm going to go back here to this screen. That sounds terrible. I'm going to this screen. And I'm going to go over here. I'm like that. Then I'm going to go like that. I'm going to back to Justin and see if Justin's in the courtroom. Yes, Justin's in the courtroom. And he says, day 8 of the LVD trial. No jury in court today. We will see what both parties in the prosecution and defense say about the jury instructions being finalized. So I'm going to put that in there too. So this is for Justin. Let me look back in this chat. Did anybody want to come up? Yeah, I want to hear from Trace too. Trace, do you want to come up? I'll put the link in the chat. So hang on. I look crazy as I can be. I think I can do this. I don't know if I can do that or not. I don't guess I want to. Okay, I'm going to put this in the Trace or KJ. Beach Bomb. Any of the mods. Did I do it? There it is. Okay. See what Nate says. Nate hadn't seen anything else because I'm guessing they're talking about those jury things. Question for Trace. Get this off of Nate. Hey, Trace.
Hey,
Wow. What a
how are you?
I'm doing good. KJ has a question for you here, Trace. She
Okay.
said, did you get any overall feeling or vibe in Lori's presence in the courtroom?
You know, Lori is so weird. She has this tendency to look out at the crowd and make eye contact you, and she's always got this big nervous. Hold on, Slinky Dog, come on. She's always got like this big grin on her face, like I. I just feel like she's not all there. She is just not she's smiling at people, you know? It's so weird. I can't describe it. Hello?
That is weird.
Oh,
But how she can just go around, as they said, nonchalant, talking about how they were being unkind to her children after she did what she did to Tylee.
yeah, she turns around and she'll talk to the attorneys that are behind her, and then she'll be facing the crowd. And instead of paying attention, she does this a lot. Instead of paying attention to what they're saying to her, she's scanning the crowd, and she's got this big shit-eating grin on her face while she's doing it. And if she sees you happen to look at her, she'll stop. It's like, and I think Megan once said she's trying to manipulate people. She's trying to win people over. But it's just crazy to me. It really is.
Pageant or something.
Yeah, exactly. Yeah.
Pageant smile and little grin to everybody, recognize each person in the crowd.
And I also say, get up here. Come on, Slinky Dog. And I also have to say that they don't take her in right away. So, and they don't lock her back up right away. So let's say after court is dismissed, she stands out there. She stands around talking with her attorneys, thinking that she's just like everyone. You know, I don't know that I've ever seen her go in before the crowd does. She stands out there. That's when she has time. Like I know Janelle was able to, at the very end of court like that, stand there. One day, all three of us kind of stood there. Janelle, I hope it's okay to say, she felt like she needed to kind of make eye contact. And it's so weird that they don't take her in right away. They don't, put her back in chains or take her. She gets to stand around and hang out and think she's
eating anything or having a Coca-Cola to drink or anything.
It's just like just like she's. I don't know what she drinks. Does she drink anything? I don't know if I've ever noticed that.
I just wondered.
We think that there's a room right by where we're all lined up. I mean, probably not even 7 feet from us is where she is at lunch. We're pretty sure because we watch her attorneys and everybody, go in and out of there constantly. So I'm sure she's in there. So, I don't know. I've never seen them bring a bunch of food or anything in there. So I don't know if she gets anything like that. But, yeah.
Which is, I'm sure.
But she does. She stands out there at the end and, shutting the place down each day and talking and laughing. And it's pretty disturbing.
And it seemed like she's having, I guess it was a really good description for those law enforcement to say she was nonchalant.
Yeah.
For the situation.
Isn't that funny? Chandler Police Department does love that word, don't they? Nonchalant.
describes how she, I mean, she was, for a person who accused of murder, she's pretty nonchalant about how she works her way around the courtroom.
Yep, exactly. You're right. She's just how she sat that one day out there in the front of the house and, hey, neighbors, joking, yeah, that's just how she is. Exactly how she is.
Okay. KJ had the same question I did. Does Lori get snacks in court?
I have not seen her snacking. No, I don't think. I don't. I do. Let me tell you, that's how I stay awake. I have some hot tamales and some really sour stuff because I just have a hard time staying awake in there.
That's what Nate said he did too at the last. I remember him saying that.
Yeah.
Okay.
So sometimes I'll be sitting there and I'll go forward and my head will pop right back up. But yeah. What looks have you noticed from the jurors? Okay, so there was a time the jurors are very deadpan. They are really good at just keeping it low key, not a lot of expression. But the one day that Kay was testifying and they were saying that she was saying that that Lori FedExed Charles' remains to her, I saw two of them literally shaking their head like what, like a reaction. They didn't have time to control it before they reacted. I also was watching when I think it was Adam who brought up zombies and they were kind of like, huh? Like they were not getting that. So that was interesting. But I mean, they just come in there and you don't read a lot from them. You really don't.
The jury members that were shaking their heads on that, what was the question she asked before?
The FedEx.
Yeah. Were they men or women or both?
There's only two women now. So, but one of them was one of the women, and then another one was a male.
Am I missing some questions? Because let's see. Does she look skinnier if the food is slop?
Who was it? Somebody was saying, oh, Janelle. Janelle was saying Lori looks thinner than when she knew her, and I didn't really notice. Her clothes are kind of baggy. She's not fashionable. When I see it, it seems like her fashion is outdated,
because she's not got the look at the fashion magazines or
exactly. And I mean, I don't look at fashion magazines either. Maybe she is in. I don't know. It just appears to me to be a little outdated, but so, and it is kind of baggy wear. But I did notice one day she was bent over the table talking to one of her attorneys, and you can see that thing. It's not little, it kind of sticks out. So that also probably may be why she has those baggy kind of jackets on. But yeah, I could see it when she bent over. So, but I don't know what she looked like before. I don't, so Janelle had made that comment.
I'm just saying, if that's what I know that I look pretty tough, but I think I could go a long time without eating if I was having to pick things out of my face.
Yeah. Yeah.
So KJ has another question here.
Yes.
Do you think Lori has done a good job pro se?
No, I don't, because I think that she could have utilized her advisory council. Those two sit there. They show up every day. They're there. They've seemed very dedicated to her before when she was going to, at some of the hearings, I was watching Pamela Hicks kind of run back and forth, the interference when they were just setting up for Lori to represent herself. I see her in there in that room off to the side every day. She's there before court. She spends all her lunchtime in there. And I think it's just, Lori picks the paralegal and the investigator to sit at the table with her. I would let me tell you, I would have one of those attorneys with me there at all times. When Lori only has access to 2 of the headphones during the white noise sessions. So anytime there's a sidebar, she always has, it's not the attorneys that she picks. And it seems so rude and disrespectful in the first place. And just the fact that it's stupidity to not use them. Now, I do think Lori has some of that defense attorney snark going on. She gets up there, she asks the question sometimes, and sometimes she'll make a good point, and she'll say it in her little, snarky tone. And it's like, I think she was watching some Law and Order or something. Some of that lawyerly stuff, I feel like she has down, but she doesn't land it, like she'll make a good point, but then she doesn't know how to go back later and use it. So sometimes I think she can put on a good show for a short period, and she doesn't sound bad up there, but overall, that just the part about not taking advantage of those advisory council right there.
And so this next question sort of went into what you were saying there.
Yeah.
Have you noticed the dynamic between her and her advisory council? Here, there's another one. Let's see. Oh, was she shaking when Kay was crossing? Kay?
I heard that she was. I didn't. It's very interesting from where you get seated. The courtroom is big. It's like one of the things when people come in, they're like, oh my gosh, it's so much bigger in here than I thought it was. So whereas like when we were in Boresky's little tiny courtroom, there was not space in between. This one is just Judge Boresky is way the heck back there. Lori's way the heck up there. So it's harder to see the details of things like that. I heard she was doing that. But I did want to say, maybe touch base a little bit more on with her attorneys. If I were them, I would be really put out that they are over there, and I'm sure they have done their homework, and to be ignored like that. But when she does turn around and talk to them, in between they're exchanging notes, I think that they are still there for her. I think, I don't see them behaving annoyed with her. I would be, but I don't see them ever rolling their eyes or doing any of that with her. They show respect to her. So, when she does turn around and ask them for things, they reply, they respond. So, I think that says a lot about them. They're not in any way like, there's,
if she ever gets a chance to have another interview,
yeah,
she'll dog them like everything, though.
Oh yeah, she probably will. Yeah.
And
yeah.
KJ wants to know, have you seen her take any medication?
No. And the judge asked, I remember at the hearing, one of those first 2 hearings in December, I can't remember which one it was. I think it was Judge Boresky, because remember that one day she was with the commissioner, and then they ruled that she was competent. And so then the next day, right in a row, that we were right in with Judge Boresky. At one of those, she was asked if she takes any medication, and she said no, she did not. The judge asked her that.
I just can't imagine.
That shocked me too, because I would have just thought they had her on something to keep her competent, So.
Well, yeah, but she's subject to go off the rail, as we see, any minute. I don't think she's going to like jump the thing and try to hurt anybody, although she might.
Yeah, I just go back to the end where she's just standing out there chatting with everyone.
Okay.
How is it meeting and making a friend for life with Janelle? Oh my gosh. We had the best time ever. And I live in an RV. So Janelle came in, she stated, I told her, this is what I've got. We live in an RV in a park. We have a gazebo outside that we use as an extra room this time of year. And Janelle and I slept out in the gazebo like a tent, camping like kids, watching a movie out there, just having so much fun. She fit in. She was so not high maintenance. We swam. We went out to the river. Joe Schmo. We got together and he cooked a big barbecue. On Saturday night, he made ribs, barbecue chicken, stuffed peppers, potato wedges. We never had a dull moment. We were busy and going and having fun. My daughter adores Janelle, just didn't even want to be away from her at all. Went to court and sat outside in the hallway the whole time because she just didn't want to miss out on the day with us. And we cried when we left her yesterday. My neighbors adored her. She is just so amazing. I just love her. And yes, it's a lifelong friend, you know. It really blows my mind that, like, when you leave court for the day, because there's so much waiting. And so every day I leave court, I have like 5 new people on text, and they are amazing people. Like, it is so humbling, the friendships that are being formed. Not only like us that have formed longer term friendships, like on Crush's channel and everything, but like just in court, there's just a real bond there, you know. And I'll tell this story too. The judge or the one of the court staff, the bailiffs, or they're not bailiffs, but whatever, they, you know, the officers that work down there, brought a blind woman over, and we were all in our seats, our assigned seats and our number. And he goes, look, she's going to sit here. I don't care who's losing a seat or how you want to handle this, but she's going to sit here. So we did. We moved over, and Joe started immediately talking to her. And he filled it, and she's into true crime. She is. And we had sat there for quite a while, and she said something about Lauren. She had a cry. And I go, well, Lauren's just a seat up there. And Lauren had a migraine that day. She was late coming in. And so I said, Lauren, big fan right there. So Lauren goes over and chats with her. And Nate had given her something. Joe would walk her into court. We brought her lunch. And she was sitting right next to me, then Joe. And on the way out of court that day, Kay said, I hear I'm supposed to stop here and meet with somebody. And Kay stopped and chatted with her for about 15 minutes. And, like, these are it's really just kind people. Joe Schmo is a gentleman, and there's just a lot of friendships being made, you know. The kids and Charles bringing people together, you know.
It really is. That's wonderful.
Yeah.
That's wonderful. And I'm so jealous. Y'all, and who was it that I'm trying to think who's on the wall?
Who's on the what?
Who's on the wall of the gazebo?
Oh, Audrey Hepburn. And so
yeah.
Janelle told my daughter to go out and look at Audrey. My daughter said, Janelle, I miss you so much. And Janelle said, go out and look at Audrey. And Janelle put her fake eyelashes on the Audrey Hepburn poster out in the gazebo. Yeah. So we got a little sign. Yeah, we camped outside like little kids, you know, but and the weather was perfect for that. So
the only thing that worried me after I thought about it is I hear that nonsense talk about the scorpions or whatever, the big spiders, the tarantulas. And I was like, that doesn't sound good.
No, there's not tarantulas, but there's scorpions, but they tend to be like in certain areas. Like it's so weird. It's hit or miss. I have a friend who just lives in a place and they're just always there. And I myself have never lived in a place where we had a lot of scorpions.
Well,
but, you know, a block away, you can have them. You just have to be careful. There's a black light you can look shine, and you have to be careful, like putting on your shoes and things like that. They'll hide in shoes, but no,
We got snakes here, so
yeah, no. I haven't heard of any of my neighbors or anybody here complaining in this park about scorpions. So we haven't had any bugs in the gazebo. You'll see it because Joe Schmo did his interview with Janelle inside the gazebo.
okay.
So we do whatever we can do for extra space.
That is just something.
Yeah, I'm trying to think what else, if there's really been any. So I just really love Trina. I've watched her from the very beginning, those very first hearings when we would go down in this really small hallway and we would just be sitting there all in close proximity. She'd be there, Justin, Nate, whoever, maybe 10 people. And so she's had to have seen, who's there. But she comes in, she's so professional. She's just very focused and very serious. And I ran in the other day. I walked in, not yesterday, the day before, I walked into the bathroom and I'd pulled the door and it kind of and it was her on the other end. And she goes, "Oh, I'm so sorry. I didn't mean to snatch that out of your hand." And she was talking with somebody and she had a big smile on her face. And I had never seen her smile. And, she was just really friendly. And then I was watching her the rest of the day and she was over there chatting with Kay and smiling. And I was like, something has happened and the pressure has been let off her. She knows she's in the final stretches. She must be feeling pretty good because you could really see a change in her demeanor, so that was good because she had been very, very serious. But does the jury? Yeah, she's just so professional. There were things I know people have, and I saw it too. At one point, she was doing a lot of leading questions. Her Adam. I think I saw it at one point in time, or those witnesses right around the time of Adam, and she would, ask the question. All they would have to do is say yes or no. And she was leading. I don't think she did a ton of that. She did more of it than if any other attorney would have objected. But still, I just think she's been very professional and very experienced. And she's, that's a paralegal there with her at the table. She's, she has nobody's second chair with her. So I think that's, pretty amazing feat. So I have a lot of respect for her. And I hope to tell her that one day, that day in the bathroom, I thought about saying, "You're a rock star, you're doing that," but I didn't. There's a certain professionalism everybody maintains around the proper parties. Overall opinion of the way the judge has done. Judge Boreski, he came over one of those very early hearings in his street clothes. He came out there and he was asking, because I think Lori had said something about the cameras. And this was when it was Channel 10 cameras. And he went over there and he goes, "Hey, good morning. And how are you all?" And spoke to them and asked them the questions. And so immediately I liked him. He's patient. And then I like the fact, so when he gave the jury their instructions, he gave them
Put
examples.
some of that in the
5
beginning of
is more
this.
appropriate because that's the one that deals with deadly physical force.
Trace,
It would be.
Yeah.
So
go down.
why don't you guys talk about that?
Do something.
Okay.
And yeah, I'll
All
give
right.
you.
We'll talk to you in a little
few
bit.
more minutes.
Thanks.
Okay. Sounds good. Sure.
Okay, so not totally starting on time, but this is how things are going to go as the court.
Yeah, we're off the record.
As the court is now off the record, they'll come back on to really go over the language of these jury instructions, and it is very. And this is just for one charge: conspiracy to commit first-degree murder. And you guys are going to see how things get interesting in this hearing, and we hear more arguments are going to come up because both parties, Lori and Trina K, may not agree, and we're going to see that today.
Yeah, I'm interested to hear you ask the panel later about why jury instructions are so important. Are they more important for the prosecution or the defense? Um, it may seem rudimentary for people, like me on the outside looking in, but this they need to nail this down, and this is an important part, obviously, of the puzzle and the ending of this case, and what the jurors can make of the questionnaire, especially in a case like this, as you'll hear later on in this hearing today, why they're hammering out every little detail in this questionnaire.
Yeah, Judge Bresky going into his chambers for a little bit. He will be back, so we're gonna chat with you guys right now. Won't keep you waiting too long. Thank you to 1,000 of you watching, and not a packed courtroom like usual, because obviously evidence is done being presented by Trina K. No more witnesses to call, and jury's on break until Monday morning. But just yeah, again, I will say it was fascinating to like Lori can't just say I'm done. She said, as of this morning, as of right now, I feel like I'm not going to testify. I'm not going to present evidence. You have no witnesses to bring on.
Yeah, you have no evidence to present. um, no experts, no, nobody in the chats. I would be if I were a juror, that would stick out to me, that you provided no defense, even though you clearly throughout the trial were. It's almost like in some of her questioning, she wanted certain things to be out there.
Yeah.
Like she wanted to say something that Judge Bresky would kind of reel it back in. Look, this is not your opportunity for testimony. Almost at times alluding, look, you'll have an opportunity to take the stand in your own defense, and for whatever reason she's choosing not to take that route. And as we've said before, that would have been great to hear. I think we would all love to hear what she has to say about July 11th,
Yep.
2019.
July 11, 2019. Now, just so you guys know, we're not going to look at the jury instructions. So
Mhm.
the information that we're hearing and that you guys will be hearing from the judge as they read over some of these terms and what's quoted from the instructions, it's hard to make out exactly what's being ask of the jury, but you can sort of piece it together as they go down the list of questions, instructions, and we're going to talk to our panel about that today as they listen in as well. We have Mel McDonald, the judge, coming back on, Rachel Smith, Taylor Larson, and we have Kirk Nermy as well, Jody Arias' former attorney, who's been in that courtroom and dealt with such a high-profile case. So we're going to talk about jury instructions, how important they are going into closing arguments. I think everyone's looking ahead now. What is
Right.
Lori Vallow Daybell going to say? And Rachel Smith was the only one on the panel. After everything we heard in cross exam, 3 experts that we talked to on the panel said, you know what? I think she's going to testify. I think that's where everyone was leaning. But Rachel said, no, Lori likes to be in control. And you can see that in her tone of voice, even when she's asked if she's going to present anything. She really has nothing. And in the first trial, there were no experts called, there were no witnesses called. She had not one, and she didn't testify. It was just the state hammering her for 6 weeks.
Well, and we said yesterday too that by taking the stand, you're opening yourself up to cross. And Lori doesn't strike me anyway as the kind of person that would want to be in that position,
No.
to be forced to answer certain questions related to her life in any capacity, almost defiant in that way. So, I guess we shouldn't be all that surprised. But I think we can take a lot, at least in the last 2 days of this trial, we can take a lot from how the prosecution presented the case, and giving us maybe a small little window into how they're going to approach the next trial for the attempted murder of Brandon Boudreaux.
Here's what I'm seeing here through jury instructions. Lori is going to try to slip in language that could benefit her so that maybe one juror could read it, um, and basically read it as in a way that helps the self-defense narrative. And
Right.
that is what needs to be figured out. That's why this is so important. Because like Rachel said, the appellate court, this is critical. You get this right. Don't mess this up.
Mhm.
These instructions have to be presented and read and understood and absorbed in a certain way so that this process, this is really sacred.
Right. This is their one opportunity. And this would look bad if somehow
Of course,
that this comes back and she ends up finding a way to be not guilty. So I think that's why they're taking their time here. Again, they're going to have today to figure it out. They're off tomorrow, and they come back Monday. Again, the closing arguments will be interesting because Trina's obviously, as we've said, very good at this, and will hammer home everything that she's hammering home in this trial. I fully expect her to take her time on Monday and methodically go through each element of this case. Just remind the jury what they've
Yeah.
already seen, but also look, that this was not about self-defense. That this was a conspiracy to murder Charles and get the life insurance money.
And she took about 45 minutes in her opening statements. It was pretty lengthy, almost an hour, and she said that she'll go for more than an hour in her closing arguments. So this starts 10:30 on Monday. Judge is going to go over a few things, some housekeeping and talk to the jury once they get in. And then we're going to have closing arguments. And then Lori's going to get her chance. So you could foresee them being done with closing arguments by the lunch recess. They're going to probably take a lunch then, and maybe they'll bring the jury back after that recess and then go over the jury instructions at like a 1:30 or whatnot, in that time frame, and then they'll get the case, and then we'll be waiting here, to see if they take more than the afternoon, or if they can stay late too. They can get dinner, through the
sure,
court and say, all right, we want to get this done tonight. They don't want to sit on this until through Tuesday.
Right, and the fact that they're doing this after the Easter break, obviously a sign that the judge doesn't want this to linger. I wonder how many objections we'll see from Trina during Lori's closing arguments. We've already seen her object to a lot of what Lori has tried to ask in crossing some of Trina Kay's witnesses. Yeah, I do wonder how long Lori plans to go and how long those objections will be and how frustrated she might be or might get when the judge says, look, you can't say that, you can't do this, you can't do that. So
There you see Lori Vallow Daybell getting seated. So it looks like we're about to get started with jury instructions. Hope you guys have fun watching this. This is not the most exciting thing, but it's very important. It's very crucial that this gets done right. And you're going to get insight into what Lori's thinking. And the question that will be asked, will she present evidence? Here we go.
All right. We're on the record in CR 2021-001704, State of Arizona versus Lori Daybell. The state is present, the defense is present, the jury is not present. This is the time set to discuss the final jury instructions. Let me confirm with the defendant that, is it still your intention to not put on any evidence?
Right now, Your Honor, yes. As
Well-
of this morning, I mean.
Well, do you anticipate that changing?
No,
All right. Because that does affect how these instructions will be read to the jury. So for now, we're assuming you're not putting on any evidence. Let's just go through page by page. I think it's probably the easiest way to do it. On the cover page, I did correct, I had 2001 instead of 2021, and I corrected the case number. The first instruction at the top, page 2, duty of jury evidence to be considered and rulings of the court. These are standard instructions in Arizona. I'm assuming there's no objection to those from the state,
no objection.
from the defense?
On page 2,
Yes.
no objection.
All right. Then on page 3, I did remove the stipulations because I don't think there were any stipulations. So on page 3, direct and circumstantial evidence, production of witnesses and evidence, redacted exhibits, those are standard. Any objection to those from the state?
Your Honor, I did object to the production of witness and evidence.
I want to hear about that because that's a standard given when we have a situation where we've heard about people like JJ Tiley, Alex Cox, we've heard about Summer, we've heard about Detective Moffett. None of those people were called at trial. So I think this instruction simply says that neither side is required to call, basically everyone that's mentioned in the evidence.
Yes, as long as the defendant is okay with it. Obviously, I've not seen that previously included in an instruction. My concern was the burden shifting potentially, saying that neither side is required. And that seems to imply or in opposition of the fact that the defendant need not present anyone anyways, ever. That's my concern with that instruction.
All right, before we talk about that one, let me hear from the defendant. Any objection to the direct and circumstantial evidence and then the redacted exhibits on that page?
No, those are fine. Your
Okay,
Honor.
what are your thoughts on the production of witnesses and evidence?
I tend to agree with the prosecutor, but
That it shouldn't be in there?
correct.
Well, if the parties are stipulating that it's not in there, I'll remove it. Is that the case?
I believe so, Your Honor.
Yes, Your Honor.
All right, by the stipulation of the parties, I'll remove that instruction. I probably should have brought my hard copy because you guys are working off a hard copy on my computer. This is kind of maybe paginate different. So now my next ones are indictment is not evidence, self-represented defendant. Any objection to those from the state,
No, Your Honor.
from the defense?
No.
All right, then on the comments are not evidence. The reason I highlighted that is it was to alert everyone that I did change the language in that a little bit because the defendant's self-represented. It mirrors what I did in the opening, what I read to the jury before opening statements, more or less, in changing it from the attorneys to the prosecutor and the defendant talk to you about the law and the evidence. Are there any objections to that instruction from the state,
Not as changed, no, Your Honor.
from the defendant?
No, it's good.
All right, then we have credibility of witnesses, and on my page 4 is testimony of law enforcement officers, but that might be on your page 5. Any objection to those two from the state?
No, Your Honor.
Defense?
No objection to the ones that are in there.
All right, then we have expert witness. Any objection to that from the state,
No, Your Honor.
from the defense?
Nope.
All right, based on the defendant's indication that she's not going to be presenting evidence, I would remove defendant's testimony. I would keep in defendant need not testify, and I would remove defendant witness prior conviction if that remains the case. So any objection to that from the state,
No, Your Honor.
from the defendant?
Nope, no objection.
All right.
Can we add in there something?
What's
Is this
that?
a time to ask to add something in there?
Go ahead.
The standard 19, the defendant statement voluntary.
Voluntariness of defendant's statements.
Mhm.
That probably should be in there. What's the state's position?
No objection.
I will add that. I'll add that right after defendant need not testify. Just making a note. All right, then we have jury not to consider penalty. Any objection to that from the state?
No.
Defense?
Nope.
All right, the state emailed this morning I think the state wants the alternative presumption of innocence, burden of proof in the Raji's. Is that correct?
Correct, Your Honor.
You want to make a record on that?
Your Honor, the current version the court has in here discusses the various levels of the burden of proof for preponderance and clear and convincing, which are not relevant to this. Case law is very clear under Portillo that the court is only required to present the Portillo instruction, which is partially on the next page in my hard copy, which explains to the jury the burden of proof for a criminal case. I think that going through other levels of burdens of proof without understanding or being provided context for that is confusing to the jury, is not necessary, and Portillo does not require it. So we're requesting the court just provide what has been mandated, which is the Portillo instruction.
What's the defendant's position?
We agree. It's confusing.
Okay. So I think that's just the last two paragraphs, right?
Yeah, from the three standards through the preponderance and the clear and convincing. So it would still have, the presumption of innocence, and then it would go to the beyond a reasonable doubts portion.
Okay, I will, by stipulation of the parties, change that instruction. So it'll read, the law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. Then I delete until the last two paragraphs. So then it will read, the state has the burden of proving the defendant guilty beyond a reasonable doubt. The rest of that paragraph. And then the next paragraph, proof beyond a reasonable doubt is proof that leaves you firmly convinced, and that entire paragraph. Is that the agreement?
Yes, Your Honor.
Yes.
Okay. So my pages are not going to be the same as yours at this point. So we'll just go through it a couple at a time. Evidence of any kind, voluntary act, and then absence of other participant. Any objection to those three from the state?
Yes, Your Honor. And the evidence of any kind, I had sent in my email that we should remove acting with the advice of an attorney. The defendant is her own attorney, so she is. I think it should just be a period after evidence is left to the defendant, period.
You're right. I will remove that sentence. So what I would propose is it would read as follows. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce any evidence is not evidence of guilt. Is that what the state requests?
I would have left the decision on whether to produce any evidence is left to the defendant, period. And then the next sentence, cutting out acting with the advice of an attorney, and then have the last complete sentence as well.
I don't have a problem with that. What's the defendant's position?
I agree.
You agree with the state's
Yeah, I
wording?
agree with, yes, just to cut that part of the sentence off.
Okay. I already deleted it, so read it back to me, state, please.
Sure. So the state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce any evidence is left to the defendant, period. Then the defendant's decision not to produce any evidence is not evidence of guilt.
So the decision on whether to produce any evidence is left to the defendant. Okay, when we're done, we're going to print out another copy and make sure everyone's on the same page. All right, let me turn to the defendant. We've addressed evidence of any kind. Any objection to voluntary act and absence of other participants?
No objection.
All right, then we have motive. Any objection to that from the state?
We did have flight or concealment in the ones that we
I'm
have.
sorry, you're right. I should have stated, I did delete flight or concealment. I don't think it's applicable in this particular set of circumstances. So then we just have motive.
No objection to motive, Your Honor.
And from the defendant?
Yeah, no objection to motive. No objection.
All right, here's where mine's going to change a little bit. I did the charged offense, each instance where it says first degree murder where it used the numerical first, I changed to a capital spelled out the word first in that, and then in the definition of first degree premeditated murder. And the reason I highlighted in here, there's a couple highlights, a person and under premeditation, she or a co-conspirator. Those are changes I made to the standard because the standard just says defendant. So let's just talk about the charged offense, the definition of conspiracy, the definition of first degree premeditated murder, and then the definition of premeditation. Any objection to those with the changes that I've stated from the state?
No, Your Honor.
From the defendant?
No, no objection to that.
All right, then where it's altered a little bit, so there was an accomplice based on liability, based on the result of the crime that I had here. I've deleted that and instead put accomplice, the traditional definition of accomplice, in the definitions section. And I think what I'm gonna have to do is we're gonna print out a fresh copy and give it to you guys when we get there. And what I've inserted here is elements of a conspiracy, scope of proof of conspiracy, proof of membership in conspiracy, which in my original draft only had the scope, I think, of proof of conspiracy in a different spot.
Correct.
But does the defendant need those printed out to review? Because I have
I
changed
was going to ask
it.
for those to be added, so I
Okay.
did review them with my advisory council.
All right, I want to make sure though that you are literally on the same page with what's going to be read.
Yeah,
So,
I would like them to be printed so I can see them.
all right. We'll come back to that when we get you a hard copy. What I wanted to ask the parties was, I initially included the Raji 4.04 for self-defense justification. But in a second look this morning, I think 4.05, which is justification, self-defense, physical force, and it specifically talks more about threatening or using deadly physical force, I think is more applicable. So what's the state's position on that, inserting 4.05 in place of 4.04?
I would agree, Your Honor. This relies mostly on physical force. Obviously, we're discussing deadly physical force here. So otherwise, the jury has to try to implant deadly physical force throughout this entire instruction.
I think they should both be in, but
Well, while we're on the subject, are you requesting any other justification instructions?
well, I was going to ask for that for 2.04A.
For what?
The 2.04A, 2.0401A.
What's that? I don't have them all memorized.
Oh, the Arizona 13204.
Is that a Raji you're referencing or a,
Yes.
hold on, let me bring them up. What's it called?
It's the Cashion. Is that what that is?
So
I was on the wrong one. So we are going to be asking for those, but
I don't think I'm clear on what you're asking for.
so we were going to ask for the 4.06, the defense of third person, the 4.07, defense of premises, the 4.11, crime prevention.
What was the crime that was being prevented?
The assault on myself, on my daughter, on my brother.
Defense of third person, defense of premises, and defense of, or crime prevention,
Correct.
in addition to justification, deadly physical force.
Correct.
All right. Those get really convoluted and long, and there's a lot of repetitive information in those, but the case law says if there's even the slightest bit of evidence, then it's error for me to not give those. So what's the state's position?
Your Honor, I think understanding the case law, the defense of third party would be appropriate. The defense of premises,
I don't have it in front of me, but I think the defense of premises requires that the person be forcing in or trespassing
correct,
on the
rather than
property.
being invited into the home. So I don't see that justification in defense of premises is appropriate, given the facts that we have here.
Let me look at it, because doesn't it also say or remain unlawfully if they were asked to leave?
I guess we have no, let's see.
There's no evidence of that specifically, but I guess it could be inferred, and I would hate to risk a reversal on something like that. So let me take a closer look at it.
I think the other question is on that goes to then the lawful possession or control of the premises, given that Charles Vallow himself was paying for the premises, which we have admitted evidence of.
The evidence also admitted is that he flew into town and came over to that house, not living there at the time. So it does infer it as well.
Well, he's on the lease. That would seem to have some apparent authority to be there, but let me take a look at it.
It refers to criminal trespass, which I think the point here is you cannot be criminally trespassed off of your own property.
So I will give the 406, which is justification for defense of a third person. I'm not going to give justification in defense of premises. It requires that there be a criminal trespass. I think it's confusing to the jury also if there's an argument that's made that he committed a criminal trespass because he was on the lease, he had authority to be there, and he was, even if he didn't have authority to be there, he was invited in to get his son.
In lieu of that, Your Honor, then we would ask to add 4.19, defense of residential structure.
That's-
record on 4.11, which is use of force in crime prevention.
Sorry, I was looking at 418 that defense just raised. Let me go back to 411. Trying to find 411, but my
So,
search is
uh,
not.
I'm going to hop back to 418. 418 is not applicable. 418 applies to home invasion type situations, and it talks about threatening or using deadly physical force. If the person against whom the physical force is threatened or used is in the process of unlawfully or forcefully entering or having unlawfully or forcefully entered a residential structure or occupied vehicle. So there's no indication that Charles forcefully entered the house. So I'm not inclined to give 418. Does the defense want to be heard further on that?
No, Your Honor.
And then was there another, you said after 418?
I just said 418 and 419. I guess that's the presumption of that.
Or, so 419. That's applied to the residential structure, so that one wouldn't be applicable if 418 is not applicable.
Okay.
So I'm not going to give 419. Did the state look at 411 yet?
Just found it, sorry. Your Honor, I think probably given Carson and the allegations that the victim used a bat, we would have to give that as well as then the instruction for the crime that they are indicating they believe Charles was committing, as is required per the
So you agree that 411 needs to be given? So that's my reading as well. So I will give 411, just so we're clear, I'm removing 404 self-defense justification. I'm adding in 405 self-defense justification, deadly physical force. I'm going to add in 406 defense of a third person. I'm going to add in 411 crime prevention. Okay, I think that brings us to the definitions. I removed deadly weapon. I think I had it in there initially because I thought it was in the justification statute, but closer read, it's not. So in the definitions that I have right now, I have intentionally with the intent to, and then intent may be inferred. Then I have knowingly, willfully, knew. And if the state is required to prove the defendant acted knowingly, that requirement is satisfied if the state proved the defendant acted intentionally. Then in the next paragraph, a defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense, and the rest of that paragraph. Any objection to those from the state?
No, Your Honor.
From the defense?
No, Your Honor.
And then here is where I've inserted the traditional definition of accomplice because I deleted the completed act definition of accomplice. So this says accomplice means a person who with the intent to promote or facilitate the commission of the offense does any of the following: 1, solicits or commands another person to commit the offense, or 2, aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3, provides means or opportunity to another person to commit the offense. Any objection to that from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Then I have a few more definitions: act, conduct, physical force, and a definition of deadly physical force. Any objection to those from the state?
You said something else I don't see in here, so sorry. Oh,
Act.
act was a previous page, sorry.
I kind of did it in alphabetical order. So accomplice went in, then act. So act, conduct, physical force, deadly physical force.
No objection.
From the defense?
No objection.
While we're in the definitions section, I'm going to have to look at when we're adding crime prevention and defense of a third party, whether there's any additional language in there that would require additional definitions. But other than that, are there any other definitions the state's requesting that I didn't include?
Other than, obviously, the state hasn't looked at either of those, either new instructions requested by the defense to see if there's additional information. So I would have to look at that prior to approving these.
Okay. But other than that, you don't have any that come to mind?
Not off the top of my head, Your Honor.
All right. How about from the defendant?
No, Your Honor.
So then the rest of this is pretty standard. It's the jury foreperson and the closing instruction, and then I have a form of verdict. Any corrections, objections to any of those from the state?
Just the form of verdict, changing the 1 ST as well to first degree.
Okay. There's no, we don't need any interrogatory on dangerous. It's automatic, right?
It would not be automatic, I
It's
don't
not.
believe so, because it does not require the use of a weapon. So we would actually need to have a penalty phase to
Okay,
have that
so
determination.
that would be done in the second phase, if there's a second phase.
Correct.
Okay. Let me turn to the defense. Those last, first of all, any other definitions that you think need to be included that I didn't include?
Hold on one second. Your Honor, we had missed one that we wanted added was mistake of fact, 205. I'm sorry, I didn't want to backtrack.
Oops. The revised jury instructions from 2 years ago don't have a 205.
Sorry, it's 204. I apologize.
Causation, ignorance of fact, is that what you're talking about?
Correct.
2.0401A, ignorance or a mistaken belief as to a matter of fact does not relieve a person of criminal liability unless, one, the ignorance or a mistaken belief as to a matter of fact negates the culpable mental state required for a commission of the offense, or two, the ignorance or a mistaken belief as to the matter of fact establishes a defense of justification. So what's the mistake of fact that you think exists?
Your Honor, it's mostly the mistaken of fact that have been presented as evidence in this case, like one shot versus two shot. You were being attacked, you weren't being attacked. It's things that the state is proposing that I'm denying.
Well, you can deny those and you can argue that, but that's not really what is meant by a mistake of fact. It refers to a misunderstanding of the facts that would somehow negate any criminal liability. In other words, you'd have to be under a false belief about a fact. I think an example might be if someone's breaking into your home or someone's coming into your home, you thought it was a burglar and you shoot them and it turns out to be your spouse. That might be a mistake of fact. So a dispute as to what the facts are, what the facts mean, wouldn't warrant this instruction unless you have something else.
That was all. That was what I was thinking.
Okay. What I think I'm going to do is I have to go back to my office in the central courthouse. I have to edit this a little bit. I'll add in those instructions. If you guys can wait here, we'll get you a clean copy by noon. Review that copy over the weekend, make sure there's no other additions, corrections, or mistakes. And then the procedure will be on Monday when the jury comes in. I'm going to ask if the defendant's ready to proceed, and I'm assuming you're going to say that the defense rests. And when that happens, we'll hand out the final instructions, and I'll read the final instructions, and we'll go right into the closing arguments.
Your Honor, then I'd asked defense previously, there are officers who are under subpoena still, that they be released at this point?
That's fine, Your Honor.
All right. And well, anyone at this point can be released from your subpoenas, is that correct?
That's correct.
Okay. I'm just trying to decide the best start time. I'm thinking read the instructions at about 11, break for lunch, and go into the openings early at 1, or you can start and have it broken up by lunch.
I would prefer the court's option of reading the instructions, going for an early lunch, and then not having my
All right.
closing.
I'll have my staff contact the jury and tell them to report at 11. And then we'll still meet here at 10:30, make sure everything is good on the instructions and the defendant's intentions to rest. And then I'll read the instructions before lunch. That may mean we break a few minutes early for lunch, but we'll have them come back at 1 and go into the closing arguments. All right, while we're here, I'm going to call the other case as well, CR 2022-001242. And the state is here, the defendant's here. I'm going to go ahead and set the official trial date to begin May 30th at 9:30 a.m. Actually, 10 a.m., May 30th at 10 a.m.
Your Honor, are we still meeting though the 29th to do strikes?
Yes, I'm going to get to that. I will set a final trial management conference to discuss the remote questionnaire and confirm we're all good to go for the second trial. For May 14 at 10 a.m.
And Your Honor, I will say okay for now. Obviously, we don't have the victim here and we didn't notify him of this hearing. So if that does not work for him, then I will ask to move that.
All right, for now, we're setting the final trial management conference May 14 at 10 a.m. At that time, we'll discuss modifications, if any, to the previous questionnaire. We'll discuss the exact timing of that questionnaire going out, but it'll go out probably May 21st and end sometime on May 26th or 27th, because the 26th is a holiday. And then we will meet on May 29th to go over those responses that the remote questionnaire produces. I'm going to set that for 1 p.m. on May 29th.
Your Honor, I received a notice from the state this morning actually about notice of 404B information for that trial. So are we going to set a 404B hearing for that as well? Would that be at the same time, or do you want to do that at a different time?
Let's discuss that on the 14th.
Okay.
I did see that come in as well a couple days ago. So the anticipated schedule for trial, let me confirm with the state. You think the second trial is similar in length to this trial?
I believe so.
So my proposed trial schedule that we talked about is going to be June 2nd, Monday through Friday, June 6th. We'll shore up those hours and where we're going to be physically located, because I don't know if we're going to be in the same courtroom or not. But tentative schedule, June 2nd through 6th, Monday through Friday, June 9th through 13th. Depending on how far we get, I may cancel that Friday the 13th, but I'll let you know at the start of the 9th or the 10th. And then I have to be dark the 16th through the 20th. And if we need June 23rd through 25th, I think that should be enough time. So that's what I'm going to screen through is those dates for the remote questionnaire.
Not the next June, you said June 23rd through the 26th, but not the 30th through the 3rd?
Yeah, and here's why I'm thinking that is you completed the state's case in this case in
It'll be,
7 trial days, 7.5 trial days, 8 trial days. And the 2nd through the 12th is already going to be 9 trial days. And then if something goes wrong, we still have the 23rd, 24th, and 25th. So that's going to be 12 trial days. And some of those trial days I can make longer depending on everyone's schedule. We might be able to start earlier.
all right, the state will ask that we screen them through July 3rd. I just think there is always things that happen, and I would much rather have a jury prepared to stay longer and have them end late than have a jury angry at us because we told them that they would be done on the 25th and something happens and they are not done on that date, or they're deliberating later. So I would ask they be screened through July 3rd.
13. That would give us over twice as many trial days as we had in this trial.
We had screened these through the 15th, I thought, of June. So
What's that?
didn't we screen these jurors through the 15th of June? So
No, May.
I'm sorry, of May. So
We screened for 6 weeks and we did it in 2.
I understand, but I guess I don't see that as twice as long as this screening.
We had 21 trial days scheduled in this first trial, and you did it in 7.
We had 28 days scheduled in the other one. In any case, that's all I'm asking, Your Honor. You can do as you wish. That's my proposal. Just
we can confirm it on the May 14th when we meet at the FTMC. I'm open to it. My hesitation is if we go all the way into the 3rd, I think we're going to run into losing a bunch of jurors who are going to go out of town for 4th of July, and they might be leaving on the 2nd or the 3rd. And I think we're going to lose a lot of jurors just based on that holiday where people go out of town. With that said, the current last day is May 11 on that trial. So as defendant, want to make a record because I am going to exclude time. I know you object to the exclusion of time.
I object to not having it by May 11th. Correct.
You want to?
What?
Do you have anything further than that?
No, just that. Yes. That I would like to have my speedy trial by May 11th.
All right. Well, we screened the first trial through May 15th. You can't do, and the state can't do, and I can't do 2 trials at the same time. Additionally, the state indicated they need to make arrangements for out-of-state witnesses to come well in advance of the trial. There's scheduling issues for myself. I'm out part of the week of May 19th. I'm out and coming back early the week of May 26th to do jury selection. Additionally, I guess the delay is of minimal prejudice given the current sentences that you're serving. For all those reasons, the court will exclude time from May 11th. The new last day will be June 30th. All right, let me get these jury instructions, an up-to-date draft for everyone. Please stick around. I'll have my staff drop that off hopefully in the next 15 to 20 minutes. And then again, when you review those over the weekend, please alert staff through your advisory council or your paralegal if there's an issue, because we're gonna have those all printed out Monday morning if we don't hear from anyone by about 10 a.m. Again, we'll ask my staff to contact the jurors and have the jurors report for 11 a.m. on Monday.
And Judge, is the court able to just email those to me, or do you want me to stay here and wait to get a hard copy?
I will email them to you and advisory council and the paralegal, but if you want, you want a copy
I'll wait for a hard copy.
yeah, I'll print out a hard copy for the defendant to take with her here today.
Thank you. Thank you, Your Honor.
All right. Are you signed up for that? Okay. All right, thank you.
Wow. So there you go. Monday morning, we'll know more.
Okay, so that was jury instructions. Riveting stuff.
That's right. The most exciting part of this whole
But
saga.
yeah, and for those of you watching, I appreciate the 1,600 of you watching. So it's important. We're not getting the full instructions, but you're seeing some of the terms that the defense may have issues with, or the prosecution may have issues with the language. And we're going to get to our panel in just a moment so we can talk about that language and just why this is such an important part of the justice system. And so we're going to closing arguments, and Lori is not going to present any evidence.
Yeah. Yeah. Well, the panel can certainly better explain why the jury instructions on this are so important. It obviously is going to be important in a potential appeal, should she be found guilty. But yes, on the surface it seems boring, but there were some nuggets that you and I both took out of this hearing this morning. Obviously we won't be able to see that just yet, but I think this is, again, all part of an important part of the judicial process. And so I'm glad that, we have as many people sticking around for it.
Okay, so we have some questions, and these we can answer. But is Lori representing herself in the next trial? Yes, she plans to represent herself. And you just heard her there saying that she wanted to have her speedy trial for May 11th. And this is the case regarding Brandon Boudreaux, her ex-nephew-in-law. But as Judge Boreski explained, they had this first trial screened through mid-May. They were told by Trina K that it would take 5 to 6 weeks, at least 2 weeks to present her case, but they weren't sure what evidence or what witnesses Lori Vallow Daybell would have. So you play it safe, conservative, and now you have 5 to 6 weeks of trial. He says it time and again, like, not like he's impressed, but he's like, you got this done fast, Trina. You did this in 7 days, and Lori has no evidence to present. So here we are. And so he has basically moved that last day for the speedy trial out, and has reason to exclude time. And there are scheduling issues, and he's going to be either out of town or dark for a certain amount of time. And so we are waiting for jury selection to begin at the end of May with those questionnaires that will be sent out, those strike-through jurors, and we're looking at June 2nd, opening statements for the Lori Vallow Daybell trial number 2. And again, Brandon Boudreaux, her ex-nephew-in-law, was shot at. Gilbert police believe it was Alex Cox, October 2nd, 2019. Brandon Boudreaux, also someone who had been deemed a dark spirit, according to the police report, deemed a dark spirit by Chad Daybell and Lori Vallow. So there's going to be a lot of similar stuff regarding religion coming out in this next trial.
Yeah, you wonder, Boreski, alluded to the prosecution. Look, we planned for 6 weeks. You took 7 days. I think if you read between the lines there, he's thinking we're going to run into the same thing again, where prosecution's going to have the case. They're going to have plenty of witnesses to call, but Lori will not. Obviously, you can't predict any of that, but I think even the judge will probably admit that they learned a lot in this first case about how Lori plans to set up her defense, which, as we know, isn't much at all. But also, it brings up a great point when it comes to jury selection and trying to get a jury. He definitely looks ahead and goes, look, July 3rd, that week, a lot of people leave town. You're going to get a lot of, if you put that out there, you're going to have a lot of potential jurors going, look, I can't be here that week. And you're going to run into potentially an issue where a lot of your jurors are you're going to have to exclude them because of that. And so, good for him for thinking ahead. He also knows too, he's moving on.
Yeah.
he's moving, so he wants to get this wrapped up, and reinforcing to the prosecution, look, you guys presented your case. The tempo was quick, and we got this done in 7 days. There's no reason why we couldn't do that for the next case. Also, the fact that they're going to have courts on Fridays in this next case, which will speed things up even more.
Yeah, I was curious to know, and yeah, they're gonna have Fridays. As far as where Lori Vallow Daybell is being held, she's at the Estrella Women's Jail. That's Maricopa County Sheriff's Office. But for now, we're gonna go to our panel of experts. Good to see them and talk about jury instructions. Got Rachel Smith, special prosecutor in the Idaho case against Lori Vallow Daybell. That was quite an ordeal. You're talking about a real 6 to 7 weeks there. That trial without cameras, and it was all audio. Was totally different from this one. The pacing just moved so fast here, and not that. I mean, you had dozens of witnesses in the Idaho trial, so of course that's why it took so long. Taylor Larson, welcome back. CharlesVallow's former attorney who helped him file those divorce papers back in January 2019, really exposing the whole Doomsday belief system as described by CharlesVallow, really his divorce paperwork speaking to us from the grave by the time we found it in January 2020, a year later. Kirk Nurmi, former defense attorney for Jodi Arias, such experience in a high-profile case, many cases, but really he's been in that courtroom here in Maricopa County and dealt with the media, the publicity, and all of that. And he is here to join us again. And then finally, Judge Mel McDonald, former prosecutor for the county attorney's office, as well as U.S. attorney for the District of Arizona, and a judge for the Maricopa County Superior Court. Welcome back, all of you guys, with such insight on this case. We appreciate you being here. Going from yesterday, when we last talked and we made our predictions on whether or not Lori Vallow Daybell would testify, here we are. And she says, as of right now, how she's feeling is she will not have any evidence to present. And you guys probably aren't surprised, but I'm going to go to Rachel first, who said she doesn't like to be out of control. She wants to be in control. And so you got it right. What are your thoughts about how things went down yesterday afternoon?
I think it's classic Lori. Lori tried to go after Nate Eaton a little bit. I mean, Nate
Duncan, yeah.
Duncan, a little bit. She tried Nate Eaton earlier, but and so her effort to work her point of view in was seen in the questions, especially the slipping in what Tylee said to the police. So I think it unfolded as the way we would expect Lori Vallow to act. She thinks she's in charge. She's going to try to control things. And I think in closing argument, we're going to see her do more than what she did, even with the witnesses. I think she's going to have her say during closing argument.
Yeah, and you saw, she still has the chance to change her mind because she needs to officially rest in front of the jury. And Judge Boreski reminded her, hey, we're going to have the jurors come in Monday morning. You're going to let them know that you're resting your case, right? That's still your intention. And so these subpoenas that you basically served on certain Chandler PD officers that you've already cross-examined, can you release them now? And she's like, okay, I'm fine with that. So the last step is her actually resting and saying that in front of the jury. She said in opening statements, the evidence will show that self-defense is not a crime, and the evidence will show that this is a family tragedy. Kirk, sum up her defense in cross-exam, because that's really all she's brought to this trial.
Yeah, I mean, I guess non-existent would be the best description I can have towards it, because much of what she brought up during her cross-examinations weren't necessarily relevant evidence. We saw her attack the lead detective over his lack of research over Nephi. We've seen her attack Mary Jo for having a date. We see her try to explore with Charles. We try to explore Charles's dating life, none of which has really been relevant to her defense. And one thing I want to address, though, when we talk about her defense and what she's put forward, we have a unique situation, and hopefully Mel can speak to this a little bit, but I've never had a situation where a defendant is afforded the opportunity to be so coy and say, Well, not as right now. I'm not going to present a case, right? I could see how if the case wrapped early, a judge might give a defendant till the next morning, what have you, to hold her to that. But he tried to convince her to get a particular answer, but she said, "Well, not at this time. I'm not planning at this time." And he says, "I'm anticipating you resting." And so there's that window open, and maybe this kind of comports with what Rachel says about Lori wanting to be in charge. She feels like she can kind of dangle this carrot at least a little more until everyone walks in on Monday morning.
Yeah, Judge Mel, I got to ask you, how would you have conducted this twice now? She's basically said, I'm going to rest, but there's that little 1% chance because the jury was not present today to hear her rest.
It was my understanding that was the jury down there, though, just not called into the courtroom.
No, the jury was not here today for jury instructions being reviewed.
I would have preferred, if I'd have been the judge, I would have said, you're resting Wednesday night. It is unconscionable to keep this case in such an undecided state. If she were to show up Monday morning and suddenly say, I've changed my mind, I now want to put on a defense, I want to take the witness stand, it is going to disrupt the entire layout of the proceedings. They've gone through jury instructions. They've gone through the instruction the defendant has to testify. It's just gamesmanship. And had I been sitting in the judge's shoes, we would have had that decision made in front of the jury Wednesday evening and then settled instructions today and had closing arguments on Monday.
Yeah, because you're right. They spent about an hour and a half or whatever it was today going over all of these instructions. And then she has said that the subpoenas can be, you can release them from those subpoenas. So if she were to take that, I don't know, 0.5% chance, and then she has no witnesses to testify. We know that. And then she takes the stand. Yeah, basically a lot of time has been wasted already, even though it has been a quick trial so far. Now back to what was said about Nate Duncan and questioning his investigation and cross-exam and getting into the dates that Charles Vallow has been on with other witnesses. Taylor, I got to ask you how it was to watch all these steamy text messages come out regarding the affair with Chad Daybell and the jury getting to see that side of the story.
Yeah, I mean, it's kind of, my reaction was kind of twofold. First, excited that we finally got to it. I know that people watching have been clamoring for these steamy text messages to be presented to this jury. And, most of us knew all along that this was going to be the final bow that Trina K was going to put on the case before giving it to the jury or passing the case to the defense. But the other part of my reaction was frustration, Justin. I mean, I said it on day one of the panel back on the first day of trial during opening statements that my number one, the thing I wanted to see the most was Chandler PD's testimony, law enforcement's testimony on the investigation of this and kind of why they waited so long to bring charges. Lori wasn't charged with this until 2 years afterwards, June of 2021, after she'd already been charged with the murders of JJ, Tylee, and Tammy, and a month after the kids' bodies have been found. So, and knowing what I know back when this first went down in July of 2019, I had Charles's family members reaching out to me, telling me, hey, can you talk to, the Detective Moffitt, who's the lead investigator of the case, and tell him, hey, look, Charles foretold of this, and he said who was going to do it, and it played out exactly like he said 6 months ago, and really exposed the belief system that we put in those divorce documents back in February of 2019. And so, I reached out to Detective Moffitt. I never got a call back. I never heard from any law enforcement after that, in fact.
Wow. And remind us the time frame again of when you called.
And this is weeks after the murders,
okay.
After Charles' murder. We're talking July of 2019. And I had multiple family members of Charles reach out to me saying, hey, here's Detective Moffitt's information. And I told them, hey, I reached out to him, have him reach out to me because, he's not reaching out to me. And, you know, I don't know why. I don't know why. That's my biggest question is why I was never contacted. You know, some of it may be that they were worried about attorney-client privilege, which is a valid reason, but they didn't even attempt to talk to me. And most of it wasn't even privileged because it was put in the court filings, which is, you know, public record. And Charles even told me, hey, if anything happens to me, tell everybody that it was Lori and her brother Alex. So, you know, to me, that's implied waiver of the privilege. And I still don't understand why it took so long for them to bring charges. And, you know, you saw Lori yesterday go after them a little bit, and she looked really, you know, the most competent, I think, during the trial was going after the Nephi thing, going after, you know, you didn't take Alex's phone, you didn't extract the messages, you know, and Detective Duncan, he's in an awkward position because he wasn't the lead detective at that time.
You're right.
And so that was, you know, he's like, well, if it was me, I would have done it, but I wasn't the lead detective. And, you know, we don't have those messages. But so yeah, just to reiterate, it was very frustrating to see that kind of play out yesterday.
So maybe, guys, maybe that's when Trina K said, why am I going to put Moffitt on the stand to have him basically get ridiculed by Lori Vallow Daybell as far as the investigation, and how it looks like to many people that have followed this that Chandler PD dropped the ball. Obviously, Trina reinforces and redirect that a lot of information wasn't known at the time, but it looks like for Chandler, Nate Duncan was the savior on this case. Now, Rachel, you got to work with him. And I'm curious to know, after Idaho announced the indictment against Charles and Lori in the murders of JJ, Tylee, and Tammy, I believe it was about a month later that Maricopa County announced the indictment against Lori Vallow Daybell and the death of Charles Vallow. Like, was that timed? Was that all discussed as far as, hey, Idaho's going to take the lead here and handle this first?
I on this one, I have to be a little careful to make sure I don't violate privilege.
Okay.
No, let me do it this way, that it is not unusual that law enforcement will coordinate based on who has the most or the most serious charges. And so it is typical for prosecutors across jurisdictions to talk about who goes first and who has what evidence. And in this case, the similar situation happened. You plan based on who has the strongest case, who has the most charges, and candidly, who has the physical person. And very typically, that's who goes first. Idaho is the one who pursued and found Lori, and that was creative, excellent work by Rob Wood and the Madison County team. They found appropriate charges to try to find JJ, to try to find Tylee, and to force Lori back. So once she was in Idaho, just by practicalities, just by research, just by resources and strength of the case, Idaho went first.
Gotcha. Okay, that makes sense. That makes sense. Kirk, I have to ask you, I still don't 110% believe Lori when she says she's not going to present evidence or testify. Can you blame me? I don't fully believe her. What is it like? Like, if you were her counsel right now, like dealing with that enigma and that person who's just so unpredictable and has this, I mean, clearly an ego, no matter what has happened, just how do you deal with that?
Well, you know, it's different because we have advisory council, right? And so if I was her lawyer, this would have been established a long time ago. So when Judge Mel says, what are you going to do? We have an answer for him right away. But ultimately, keep in mind that role of advisory council is a lot different. You know, I've heard people commentate, hey, why aren't they objecting, things of that nature? They're not allowed to do that. She is the entire defense team, if you will. She's the head of it. She's the one who gets to make all these decisions. And obviously, testifying is something that's left to a defendant, whether they're representing themselves or not. But, you know, if you have an attorney, you're working with that attorney to come up with a strategy. What we have now, and I agree with you, Justin, because, you know, one of the things I thought was most interesting about this hearing, I've been with jury instructions many a time, but for the judge to say, I assume you're going to rest in front of the jury, that kind of coy response at this time, what have you, whatever she said, makes me think like you do, that that door is open. I mean, we have a person who hasn't necessarily told the truth all the time and has an unclean mind.
So is there a chance, like, let's just put
We have a
little echo there. All right.
No, Mel.
It's coming from, okay. So hypothetically, and I'll ask you, Mel. Oh, the echo's coming from Mel. Okay. All right. I'll go back to Rachel on this. Or actually, this is what I want to do. We want to talk about jury instructions. So there was a point in this hearing where they discussed a certain question, and we sort of got an argument from Lori regarding defense and third person defense. So I'd like to go to this, Robert, if we could. It's going to be bite number 2, court discussing the jury questions. You don't have those. Okay. 1 second. All right. In the meantime, okay, before we get to that, sorry, we'll get through these technical issues. Rachel, is there a chance that if she wants to testify, judge could say, no, you had too much time, and at the Monday late hour as the jury has just gotten there, or I don't know. I'm just trying to go through all the scenarios of what could happen.
Absolutely. In theory, that if Lori came in and said, I've thought about it, I've talked to counsel, I changed my mind, and I want to testify, in theory, the judge could I think if Lori says she wants to now testify on the advice of advisory counsel, I think the judge is going to let her. It would be a terrible position to be in. If the court had nailed her down, as Judge Mel McDonald said, which is either last night made her rest in front of the jury or even brought the jury in this morning and made her rest, then he would be in much more solid, you're done. But I think if Lori comes in Monday morning and says she wants to testify, I don't even think the prosecution will object. So I don't think Lori's going to do that. I don't think Lori's going to let anybody be in charge but Lori. But it is very likely, should she do that, I really think the judge would be hard pressed to not let her.
From your experience being around her, I don't know. Do judges? It looks like this judge has not. I want to say take it easy, but he's been very patient. He's given her some leeway, and there were times where I felt like Judge Boyce did that too. Is that a pattern? What is it about her?
Well, candidly, I don't think it's unique to Lori. I've tried other pro se cases with standby counsel, and even in that case, it was a case in rural Missouri for a double homicide, where the defendant insisted on trying his own case. And even going right after I rested, the judge took a break and gave Carl Hollis, that was his name, said, "Are you sure you don't want to testify?" And he said no, and then we get instructions done, and then he came back and said, "Yeah, I think I want to." So the judge gave him a little bit more time, and then he changed his mind again. These pro se, I know in Arizona, a lot of people call it pro per. When they represent themselves, the courts, in my experience, the judges who are patient and thoughtful and mindful of that appellate record give pro se defendants a little bit more opportunity so that a record on appeal is really clear that nothing happened to affect this person's rights. So the judge isn't really doing anything unusual in pro se cases. He's, in my experience, doing what judges do.
Gotcha. Okay, well, we're going to listen to her basically talk about her decision not to present evidence. We're going to go with bite 1.
All right, we're on the record on CR 2021-001704, State of Arizona versus Lori Daybell. The state is present, the defense is present, the jury is not present. This is the time set to discuss the final jury instructions. Let me confirm with the defendant that, is it still your intention to not put on any evidence?
Right now, Your Honor, yes. As of this morning, I mean.
Well, do you anticipate that changing?
No.
All right. Because that does affect how these instructions will be read to the jury. So for now, we're assuming you're not putting on any evidence.
Okay, so just your thoughts on that, Judge Mel.
That panic of that panic of that panic of
All
that
right.
panic of that panic of
Judge,
that
we'll bring
panic
you
of that
back,
panic of
maybe
that
on your
panic of that
phone.
panic of that panic
Go
of
ahead and turn that off. Okay, Kirk, let's go to you.
Yeah, your question again, Justin?
Yeah, just your thoughts on how that was handled and kind of gauging her attitude and her, I don't know if that answer was very concrete.
Yeah, I picked up on the same things we talked about earlier. That answer isn't concrete. It does make me think that that door is open. She's got, 72 hours or thereabouts to consider and go back and forth in what she decides. And, Rachel may be correct that she doesn't want to give the situation where she gives up control. I think she's going to go back and forth on it. And that door is open. I mean, until somebody rests in front of the jury, until the defense rests in front of the jury, that door is open. And if she were to pop in there Monday morning and say, you know what, Judge, I've changed my mind, I want to testify, Rachel's right that neither the judge nor the prosecutor could really object to it because she has an absolute Sixth Amendment right to do so. And he did not force her to close the door. And that's the concern that arises with the procedure that's taken place now, because that does leave that door open, and obviously Trina, I'm sure, would be well prepared to cross-examine Lori should she decide to take the stand Monday morning. But really, I think some finality on that should be something that the court's looking for, because it will alter the jury instructions. Because keep in mind, we have instructions about the defendant need not testify, the defendant need not present any evidence. If she does testify, there could be other issues from which instructions might be appropriate. So, he's relying on her word, as you say, but she has consistently herself an out, whether that is to garner more attention, to get people to talk about whether or not she'll testify or not. I don't know, but the door is still open and it does concern me.
Taylor, is this the Judge Boreski that you know and you're familiar with?
It is. It is. But at the same token, I think that it's a little risky, as the others have kind of said, of him leaving it open. I'm not surprised that Lori is not really being committal on her decision, as of this morning, Your Honor, because it is a game to her. And I've thought this whole time that, this whole thing of her self-representing, it is about control, but I think it's also a game to her. She's shown zero remorse throughout the trials in Idaho and the trial here, because this is all a game and a charade to her. And she's a pageant queen. This fits right into her background, and she loves to be the star of the show, and she wants that light on her. And she knows if she holds it till Monday, she still has it a little bit more. I don't think that she's going to change her mind and testify because of the control thing, and she doesn't want to be cross-examined and given that control up of being able to control the narrative. So I do think it's just straight up gamesmanship.
Okay, we're going to get back into those jury instructions. So I want you guys to listen to bite number 2.
So we were going to ask for the 4.06, the defense of third person, the 4.07, defense of premises, the 4.11, crime prevention.
What was the crime that was being prevented?
The assault on myself, on my daughter, on my brother.
Defense of third person, defense of premises, and defense of or crime prevention.
Correct.
In addition to justification, deadly physical force.
Correct.
All right. Those get really convoluted and long, and there's a lot of repetitive information in those, but the case law says if there's even the slightest bit of evidence, then it's error for me to not give those. So what's the state's position?
Your Honor, I think understanding the case law, the defense of third party would be appropriate. The defense of premises.
I don't have it in front of me, but I think the defense of premises requires that the person be forcing in or trespassing
Correct,
on the
rather than
property.
being invited into the home. So I don't see that justification in defense of premises is appropriate, given the facts that we have here.
Let me look at it, because doesn't it also say or remain unlawfully if they were asked to leave?
I guess we have no, let's see.
There's no evidence of that specifically, but I guess it could be inferred, and I would hate to risk a reversal on something like that. So let me take a closer look at it.
I think the other question is on that goes to then the lawful possession or control of the premises, given that Charles Vallow himself was paying for the premises, which we have admitted evidence of.
The evidence also admitted is that he flew into town and came over to that house, not living there at the time. So it does infer it as well.
Well, he's on the lease. That would seem to have some apparent authority to be there, but let me take a look at it.
It refers to criminal trespass, which I think the point here is you cannot be criminally trespassed off of your own property.
So I will give the 406, which is justification for defense of a third person.
Okay, so I know that's a lot, and for the people watching and they're trying to figure out where is Lori going, Kirk, go ahead, and you've been in this, Arizona courtroom. Just if you could translate the language there for us.
Well, Lori's really trying to, this isn't going to sound very complicated legal analysis, but she's throwing everything against the wall to see what'll stick, right? She wants everything, to her knowledge of lawyering, she wants everything related to any form of self-defense, whether the evidence supports it or not. So she's going to push those issues. And one of the things we heard Judge Boreski say during this is, I don't want to risk reversal over blank. There just needs to be a slightest bit of evidence to support the giving of the instructions. So I think he is well advised to talk about assaults on the other, self-defense, what have you. And you can see he's really giving meaningful consideration to whether or not this property, unauthorized invasion of the property, is appropriate. I think he's probably going to wind up, I think the state's arguments were better taken on that, because like I say, Ms. Vallow just sees any kind of defense instruction that the jury is given as a good thing, whether it's actually supported by evidence or not. She's not doing that legal analysis. The state and the judge are.
Yeah, Rachel, we know that Charles did not trespass into that home. I mean, everybody here knows that he was going to pick up JJ Vallow, and then as far as the assault, again, he walked in to go pick up his son, from what we know.
Right. I agree with Kirk. Lori is throwing everything but the kitchen sink in there. And the goal is to confuse the jury, or at least one juror, because the more you can get them to fixate on one little thing, one little hook, the more complicated the law can seem to a jury, the more possible it is to get one or two of them to just hang it. So it's not unusual for people in a situation to try to just throw everything in there the goal being to confuse the jury. The court is clearly paying attention to the law, clearly going to follow the law. And I think legally he would be very safe to exclude that one. Charles was on the lease. He was invited in there. It was his child. And we don't actually have any evidence he was ever asked to leave. So
Yeah.
I think the court will be able to exclude it, but Lori's strategy is something a lot of people do.
Okay, so Judge Mel, this is not, do you agree this is not uncommon? Trying to like sneak in sort of a question or instruction that could possibly confuse a juror.
I'm sorry, I'm having difficulty hearing you. I'm trying to get the speaker working on my phone. I think somehow Lori's gotten hold of my connection. Let me go try to get some earplugs in,
Okay.
and then I'll see if I can hear you.
Yeah, technical difficulties do happen, obviously. Taylor, just your thoughts as Lori tries to once again smear Charles, even by jury instruction.
Yeah, I mean, there's two ways of her to play this defense coming into this trial, right? It's to claim self-defense, claim that Charles is this horrible person. You know, she kept saying let the evidence show, yet she's not going to even present any evidence. So I don't know how that's going to play with the jury. But you know, the evidence I think has shown the opposite. And you know, these jury instructions are very, very important, as we've seen throughout some other high-profile cases, including the Karen Reed case in Massachusetts, which is just now getting ready for trial number 2 to start. And the issue from the first trial with jury instructions, you know, being confusing for the jury on how to submit a verdict form, you know, that was taken up through appeal, and I think is still on appeal. You know, they're aiming for the U.S. Supreme Court in that case. So this insight that we were able to see today, even though I've never been involved in any jury instructions, I understand the importance of it. And it's kind of cool to see, you know, the insight of the judge, the state, and the defense going back and forth with it, even with, you know, Lori representing herself. Like Kirk said, you know, it's only really the state and the judge who are doing the actual legal analysis of these things. But it is important to go word by word because words matter.
Yeah, Kirk, what was this process like for you? How important are these instructions related to a potential appeal?
Well, I think, you know, lawyers and all parties involved take them very seriously. But at the same time, you know, when we talk about where the rubber meets the road, you don't know if the jury really even opens the packet of instructions or not. They might go through, you might have a jury that goes through every word. You might have a jury that doesn't take a look at a lot of them. But they're important, you know, for appeal. I don't think that, you know, we got to remember here, to put in context, Justin, that probably somewhere about 5% of the cases are successful on appeal. That's probably maybe even being a little generous. So while you want to protect the record in that, it's not going to be a huge deal. Jury instructions also too aren't necessarily that much of a fertile ground for appeal unless they're blatantly obvious. If self-defense were to be laid off this case, something of that nature, Lori was not able to put that on the instructions. That really could be something for fodder. But when we talk about some of these other instructions, when the judge gives these well-reasoned responses on the record, because remember, this hearing today where they're discussing jury instruction is the part of the record that relates to the appeal. So if an appellate attorney says, you should have given the instruction related to, you know, him being there trespassing on the home and Lori acting to prevent it, the Court of Appeals goes to that record and they say, this is what the judge looked at. This is what the judge thought about and made, and judicial discretion allows him to make the ruling he made. Because one of the reasons why we have a limited amount of appeals get overturned is because judicial discretion is a big umbrella, and it's easy for a conviction to be upheld hiding under that umbrella.
Okay. Now I want to ask Rachel, we chatted about this morning via text. So a lot of people wonder why Charles Vallow's not being shown in evidence as far as body cam footage from Gilbert police back in January 2019. just can you tell me why we may not have seen more of Charles than people expected?
Yes, uh, under the law, the statements of victims, statements of witnesses who are not in the courtroom, regardless of the reason they're not in the courtroom, are not allowed to be played. They're not admissible. And so, with the Charles not being available, then his statements, his recordings, like those with Tylee, they will not come in.
Hmm. Okay, yeah, because I think a lot of people think that's huge evidence. Charles pleading his case to Gilbert officers and talking about Lori's um, mental health. But yeah, thank you for answering that. And I want to ask you if you could play the role of Trina K right now, what does closing arguments look like on Monday to the jury?
Closing arguments really focus on those texts. They focus on the 2 shots. This wasn't self-defense, stay away from me. This was murder. And focus on Lori's attitude and demeanor afterwards. And then I would spend a considerable amount of time helping educate the jury on what does conspiracy mean, what is not self-defense, and helping make sure that we don't have anybody sitting on that jury who is a sleeper, who is confused by the idea of conspiracy and confused by the idea that someone themselves has to actually pull the trigger or physically participate in the crime. Those are a couple of vulnerabilities on conspiracy cases that you see a lot. Some jurors have trouble with the idea that words alone can be a crime. And so I would spend time with those jury instructions. I would spend time really making clear Lori's leadership and control and manipulation of Alex, and Lori's motive and Lori's attitude and demeanor, which shows her motive and her desire for Charles's death.
And like we've seen in other closing arguments, maybe some exhibits will be brought back out to
Yeah.
reinforce visuals. Could we see the Walgreens video that everybody's been pointing out of Lori walking in and not barefoot, even though she had made a claim that she had ran out of the home after the shooting barefoot? Is that, I mean, wouldn't people see that's a lie? I mean, I see something on her feet.
Well, I think yes, you will see visuals. It was a visual opening. There will be visuals in closing argument. The extent to which she relies on one piece of evidence that's subject to interpretation, that can be risky for a prosecutor. So I wouldn't anticipate something that people being, the linchpin. Sometimes the public or general normal people want that one I gotcha moment. This isn't a one simple case of I gotcha. There's no eyewitness left to talk about it. There is no one Charles will die today statement. This is going to be a very organized, concise, timeline driven, definition driven, very clean closing argument, which will lay a foundation and build people to that ultimate call of action, which is convict her of conspiracy to commit murder.
Okay, Kirk, you're the defense now. What is the closing argument going to look like or should look like for Lori Vallow Daybell?
Well, Justin, I gave up defense work so I wouldn't have to do this sort of thing. But okay, here you can put me in this position.
I got
Here we go.
to.
One of the things that I would be focusing on is those 2 elements that Rachel just mentioned. In order to have a conspiracy to commit murder conviction, we need to have a conspiracy and we need to have a murder. Now, I think Rachel's right in her conclusions, but if I'm the defense attorney, I'm saying, wait a minute, ladies and gentlemen, look at all these instructions on self-defense and look how Alex Cox was not charged with a crime. And look at these instructions. You have to ask yourself, why does this help prove the state's case that there was even a murder? Then you go towards the conspiracy, and we talk about something that Taylor mentioned days prior, this idea of putting it all on Alex, whether you want to call him throwing under the bus, what have you. But we know that he did pull the trigger. So there's a little bit of leeway there to say, okay, this was Alex's actions. This was Alex's conduct. This wasn't mine, and divorce herself from that as best she can and try to sow seeds of reasonable doubt. Again, not saying that this is correct, not saying this is factually sustainable, but that's the only argument she has to make. The problem is this isn't what she did during the trial. And
You're
so
right.
I don't see her doing it in closing arguments either. We're probably going to hear more about Nephi and dates and things of that nature. But yeah, that would be the strongest argument that Miss Daybell has.
Yeah, she has not thrown Alex under the bus. Instead, she has said that the evidence shows that this was definitely legitimate self-defense. And she's talked about Charles as this more of a villain and someone who's intimidating. And she has talked about Tylee Ryan as someone that was trying to protect her mother. And that's where the jury just doesn't know what we know. And to hear that, Taylor, to know that she murdered her daughter and then uses her as a pawn in this as a reason for the self-defense.
Yeah, I mean, it's sad, but at the same time, no one matters more to herself than Lori, right? She is the queen. She's the know-it-all. She's the narcissist. She's the leader. And, so for her to just dispose of Tylee and claim, that it was Tylee who instigated this or was a pawn in the game, as you say, it's not shocking in the least to me. What is kind of shocking is that she really hasn't thrown Alex under the bus yet. And I don't, I agree with Kirk. I don't anticipate her doing so in closing, even though it's really her best shot that she has to say that he acted as a lone wolf and she had no idea that he was going, she had no idea that he brought a gun. She had no idea that he was going to shoot Charles, so we'll see what happens on Monday. I know I'm excited to kind of get this more wrapped up and get to a quick deliberation is my hope so that we can finally get justice for Charles and close this chapter on that book for him 6 years later.
Yeah, you bring up some good points. If she was taking the stand, she could have those questions scripted to say she didn't know what Alex was going to do. But she has never blamed him, just like in her trial, she never blamed Chad. Thank you so much to our panel for being here, even on an early day without a jury, and the state has rested its case. Lori Vallow Daybell has rested her case 99.9%. We believe we're waiting for that 0.1%. But you guys, thank you so much, and we'll see you for closing arguments.
Right.
All right.
Thank you.
George.
So y'all, I think that we should go on and close this one out. And we'll be back Monday morning for jury instructions and closing arguments at 1. So we'll have something set up for that. But also, Krisha may have, well, I think Krisha will be on Sunday for her usual time. But also, there may be another video. So y'all look for it. Y'all keep your ears open for a notification in case Krisha wants to come on and talk about this. Excuse me. Also, remember why we're here. We're here for justice for Tylee and JJ and Charles and Tammy and Joe Ryan. And that's why we're here. We're here to get justice through understanding. And I appreciate everybody that's been here supporting Krisha's channel. So we'll see y'all soon.